Dear all, good morning, good afternoon, good evening, depending on where you are. We start our second day of the arbitration conference of the Ukrainian Arbitration Association, and I'm delighted to introduce the keynote speaker of our conference, Alexei Moore. Alexei Moore is president of the ICC International Court of Arbitration, the most preferred arbitral institution in the world according to the recently published global survey by Queen Mary University London. He has served as parties counsel, arbitrator, or expert in more than 260 international arbitrations, both ad hoc and before many arbitral institutions. He established his own arbitration practice in May 2015 after having founded Castaldi Moore and Partners in 1996, a French firm specializing in arbitration and dispute resolution. He is also the author of numerous books and publications in the field of international business law, private international law, and arbitration law. He is founder and former editor-in-chief of Les Cahiers de l'Arbitrage, the Paris Journal of International Arbitration, a leading French publication in the field of arbitration. Since 1st July 2015, Alexei Moore has been the president of the ICC International Court of Arbitration. Before that, he served 2 terms as vice president of the court. Among his past appointments, I could also mention vice president of the ICC Institute of Business Law, co-chair of the IB Arbitration Committee, LCA court member, council member of the Milan International Chamber of Arbitration. Alexei is also a member of a large number of scientific and professional institutions dedicated to arbitration and private international law. He is the founder and former president of Paris Place d'Arbitrage, Paris, the home of international arbitration. We are very happy to welcome Alexei today at our conference. Alexei, the screen is yours.
Thank you very much, Olena. I hope you can hear me well. And I'd like to thank you, Olena, and to thank the Ukrainian Arbitration Association for inviting me to this event today. And this speech comes at a particular time for me because, as you may know, I will leave my position as president of the ICC Court of Arbitration next month. And these 12 years at the court, 6 as vice president and 6 as president, have been as challenging as they have been rewarding. I've been deeply honored to chair the court during these years. These have been years of reform, of transformation, of changes for the ICC, for the court. These have been years of significant growth for the court, and also years during which the court has been faced to a fast evolving arbitration marketplace, to a very, very fast evolving arbitration environment, to a more diverse, more competitive, and more demanding arbitration marketplace. These have been years of intense activity for the court, with 2 sets of amendments to the rules, with the opening of 3 new case management offices in Sao Paulo, Singapore, and now Abu Dhabi, and with the elaboration of a deeply transformed and renewed practice note. And as this journey comes to an end, it is also time for some general reflections on the past and also for thinking on the future. The arbitration world has been characterized in the past 15 years by a number of important evolutions, and I will also mention the 3 which I see as the most significant ones. The first is the consolidation of the central role of arbitral institutions. That trend has begun in the last decades of the last century, but the predominance of institutional arbitration as opposed to purely ad hoc is now fully confirmed. And that means that the net of arbitral institutions has now become the structure and the backbone of arbitration as a global system of justice. That also means that institutions concentrate much more powers than they historically did. And that means that institutions are a tool for any future significant reform of the law and practice of arbitration. This should not surprise anyone. We should not forget that in 1958, the ICC was at the initiative of the process which led to the adoption of the New York Convention. Should be one of significant diversification, both geographically and from a generational and gender perspective. Geographically, arbitration is no longer the Western industry that it used to be 20 years ago. Look at the recent Queen Mary White and Case survey that Olena has mentioned. You will see that more than half of the respondents originate from Asia, and that shows how committed the Asian community is in arbitration. You see around the world new institutions being created almost every year or every month. You see the rise of regional institutions. You see the development of new arbitration seats. You see new arbitration committees developing around the world. You see a much more environment. From a generational point of view, arbitration is no longer an industry which is for old, I would say, very senior practitioners. You see now, and we see at the court, a new generation of arbitrators in their 30s and their 40s producing excellent awards, and there is, without any doubt, a very, very important process of renewal. From a gender perspective, some of you perhaps may remember that 15 or 20 years ago there was only one woman in the court, and that was our friend Antonia Zdemolica. We now have gender parity. We have 20% of our arbitrators confirmed. We have a population of 1,600 arbitrators confirmed or appointed every year, and the proportion of women is rising every year. And the consequence is that in a much more diverse environment, there is more need for consensus on transnational rules. There is increased need for the development of soft law rules. There is an increased need for the establishment of a level playing field, because arbitration is no longer a community of limited practitioners who know the non-written rules of the game. It is now an open and diversified market, and in an open market there is need for written rules, there is need for legal certainty, and there is need for equal access of all to the rules and to the practice of arbitration. And the third trend, which is noteworthy, is of course the intensified public scrutiny to which arbitration is submitted, not only in the field of investment arbitration, of course, but also in the field of international commercial arbitration, where significant public interest is often at stake. Let us not forget that in 2020, about 20% of our new filings at the ICC involved a state or a state entity, and this goes with a growing expectation for more transparency, for more accountability on the part of arbitrators and institutions, and for more efficiency, of course. And in this fast evolving landscape, I would like to suggest that three questions deserve the urgent attention of arbitral institutions and of the international arbitration community. These questions are potential evolutions for the future, they are field for reform, and they are conditions, I think, for the continued legitimacy and development of arbitration as the normal way of resolving international disputes. The first of these three questions on which I would like to say a word today is the question of conflict disclosures. Arbitration is an industry that is fundamentally based on trust. It is exactly like the banking industry. Banks rely on the trust that depositors have that they will be able to recover their money. Arbitration rests on the trust of the parties that conflicts are disclosed in a forthcoming and transparent way. And this is particularly important in an industry where international arbitrators necessarily entertain multiple relationships with parties, counsel, and other arbitrators. if conflict disclosures are not made in a forthcoming and transparent way, then the integrity of the entire system goes away. Disclosures are the necessary condition for the parties to be able to exercise what is a fundamental right. It is the right to object to the nomination or the appointment of an arbitrator, or the right to challenge the continuous participation of an arbitrator in an arbitral tribunal. If a disclosure is not made, the parties are deprived from the information that they need to exercise that right, and therefore the question becomes a question of the validity of the award, with, of course, very, very significant and serious consequences in case of nullity. And I would like to draw your attention to a significant development, which is the recent decision made by the European Court on Human Rights last week, I think, in the case Becchetti versus Italy, where the European Court of Human Rights has decided that the lack of disclosure by an arbitrator, and in that case it was the participation of the arbitrator in the board as vice president of the board, the mother company of the respondent party to the arbitration, that had the effect of depriving the other party from the opportunity of challenging that arbitrator, and that has resulted, says the European Court of Human Rights, in a violation of Article 6.1 of the European Convention of Human Rights. That's very significant. That's the first time that the European Court of Human Rights addresses that particular question, and that confirms that the transparency of conflict disclosures is a fundamental condition for arbitration proceedings to comply with the requirements of due process. If disclosures are not made, then the entire process becomes questionable. Now, the problem is that we still lack an internationally standard for disclosures. The IBA adopts a subjective standard, so does the ICC, which is to say that disclosures need to be made in the eyes, according to a standard in the eyes of the parties. Arbitrators need to disclose every circumstance that is likely to question or to put a doubt on their independence or impartiality in the eyes of the parties. Whereas the model law adopts what some characterize as an objective standard, which is in the eyes of a fair-minded and informed observer. Those of you who have read the recent Halliburton decision of the United Kingdom Supreme Court will have seen that the court addresses that question by confirming that the standard for disclosure in the United Kingdom is an objective one in the eyes of a fair-minded and informed observer. And it's interesting to see that the decision describes what is that fair-minded and informed observer. In who knows the case, someone who is able to exercise fair and independent judgment, and therefore is able to decide objectively of what disclosures deserve to be made and what disclosures do not deserve to be made. Now, this, for me, is very problematic. Why is it problematic? Does it make a difference that the IBA adopts a subjective standards for disclosure as opposed to an objective one for the model law? Perhaps in the practice of institutions, it doesn't, but conceptually, it makes a lot of difference. It makes a lot of difference because the objective standard in the eyes of a fair-minded and informed observer implies conceptually that the arbitrator will exercise some level of judgment as to whether circumstances should be disclosed, not only because they are susceptible to raise doubts in the eyes of the parties, but because reasonably in the eyes of a fair-minded observer, they are so. The problem is to allow the arbitrator to cast a judgment on his or her own neutrality or independence. And that's why I believe that the subjective standard that is adopted by the ICC is preferable. It's preferable because it implies a broader standard. It implies broader disclosures. It implies that the arbitrator should not put himself or herself in the foot of the judge. He or she should not be the judge of his or her own conflicts. Now, is the subjective standard as approved by the ICC or the IBA ideal? Probably not. There still is room for moral hazard. You still have the possibility, exactly as under the objective standard, that an arbitrator would not disclose, either because consciously decides not to do so, which is of course very bad, but also because of unconscious biases. You can have a situation whereby a young arbitrator who's very much willing to take a case will, at the end of the day, consider that the circumstance that would risk him losing the case should not be disclosed. You have experienced arbitrators who believe that they know better than anyone else, and therefore they know that the circumstance is not relevant, or they believe that the circumstance is not relevant, whereas that determination should not be made by the arbitrator. It should be made by the institution or by the judge. Now, there are encouraging signs on this front. I would like to draw your attention to what UNCITRAL and ICSID are doing with the project for a code of ethics for adjudicators. And it's interesting that in Article 10 of that draft code of ethics, ICSID and UNCITRAL adopt a standard which is a subjective one in the eyes of the parties, but they complement it with a list of objective circumstances that arbitrators have to disclose. So it is a mix of the objective IBA ICC standard with a purely objective standard, which is in essence the obligation to reveal some circumstances which are listed. And the ICDR has a formal disclosure which is close to that, and I think that is the way for the future. So the first thing I wanted to say is that moving ahead in the future, the arbitration community will need to address that question. There will be the need, I think, for a globally accepted standard providing from full transparency in conflict disclosures. And I think that what ICSID and UNCITRAL are doing now is the way to go, not only for investment arbitration, because the draft code of ethics is for investment arbitrations, but also for commercial arbitration. Now, the second evolution that I would like to see in the future is on the front of transparency, i.e. the endorsement by institutions and by the arbitral community of a principle of full transparency, not only in ISDS, in investment arbitration, but also in international commercial arbitration. Arbitration, and in particular commercial arbitration, is still embedded in a culture of secrecy, which, in my view, which checks its efficiency and which threatens its legitimacy. There should be now a transparency revolution in arbitration, and this has several aspects. The first is transparency in institutional rulemaking. Decisions made by institutions on challenges, on prima facie jurisdictional determinations, on consolidations, as well as other decisions which are such as to significantly affect the rights of the parties. Reasons should be provided. Some institutions do that, the LCIA, the ICC, and others, except, of course, that should become a general practice. Second, transparency of the institutional governance of institutions, the composition and selection of board members, of court members, who is sitting in these bodies, who is sitting in other decision-making bodies of the institution, the adoption of governance rules such as to ensure the full independence of the arbitral institution from their chambers. All this will become a fundamental condition of the integrity of the system, and there will be the need, again, for internationally accepted rules across the board that all institutions will adopt. Awards the need to move away from the current opt-in rule of confidentiality, on the basis of which awards are only published on a piecemeal basis if the parties consent to it, to go toward an opt-out principle, and that is the reform that the ICC has recently adopted, whereby awards would be, as a matter of principle, published with the names of the parties, of the arbitrators, unless one of the parties object. And why should awards be published? First, because allowing the parties to understand, who is sitting in other cases and outside cases will, of course, better inform appointments made by the parties. Second, because allowing arbitrators to refer to past cases in a more systematic manner will enhance the quality of the awards. We should not forget that in many industries, like construction, for example, there are others, most of the disputes are resolved by arbitration. The fact that awards are not published, the fact that there is only access to them on a piecemeal basis, as opposed to a systematic access to awards, is something that hampers the ability of arbitrators to have access to precedents and therefore to refer in their awards to what other tribunals have done in similar situations. And third, because the systematic publication of awards will allow the formation of an arbitral jurisprudence, kind of a jurisprudence constante, and will allow arbitration to contribute to the formation of the rule of law. Again, this is particularly relevant in industries where most, if not all, of the disputes are resolved. The third point of reform and future evolution, I addressed the question of conflict disclosures, which I think you heard. I addressed transparency,
Yes.
and I was addressing now
Yes.
the question of advocacy and counsel conduct in arbitration. I don't know at what point I've been disconnected, but what I was saying is that the duty to arbitrate in good faith is fundamental, that there are questions that are addressed by soft law rules such as the IBA guidelines on party representation that are of fundamental importance, such as what are the duties of counsel in an international arbitration? Is there a duty of candor? Does counsel have a duty to advise its client to comply with document production orders? Should counsel refrain from submitting or correct false or misleading expert or witness evidence? Should arbitral tribunals have the power to discipline counsel? All these are fundamental questions for the integrity of arbitration, and these questions cannot be left to domestic law. They cannot be left to domestic professional codes, to bar rules, which include inconsistent solutions. There is the need for transnational rules. There is the need for globally accepted transnational code of level playing field. Again, as I said, the LCIA has to be commended for having introduced such rules. First, the IBA has adopted in 2013 its guidelines for party representation in international arbitration. These guidelines have been adopted by institutions such as the ICC and SICA. Institutions globally should now develop this and develop rules on counsel conduct. So to conclude, what I was saying is that these three reforms, establishing a global standard, ensuring the full disclosure of conflicts, establishing transparency for institutional decision making, for governance, for the publication of awards, establishing a global standard for advocacy and counsel conduct. These are reforms which would go a long way in establishing the legitimacy of arbitration in the decades to come, and to strengthen arbitration as a global system of justice. And as I said, these reforms cannot, in my view, be made by states, because arbitration is global and because states, of course, will not be able to establish these global standards which are needed. The route of an international treaty is also fraught with difficulties, so that it is the self-regulation of the international arbitration community by institutions which would to implement much needed reforms. Thank you very much.
Dear participants, we continue the program of the second day of the UAA Annual Arbitration Conference, and we move on to the session number 3 about court assistance in taking of evidence in support of arbitration. This session would be moderated by Alexander Drug, board member of the Ukrainian Arbitration Association and partner at Sayenka Harenka, Kyiv, Ukraine. Colleagues, the floor is yours.
Welcome. Welcome everyone to the second day of the Ukrainian Arbitration Association Annual Arbitration Conference. I am pleased to start this first session of the day and third session overall. It is dedicated to a very interesting topic. It is court assistance in taking of evidence in support of arbitration. We have a great and exciting lineup of speakers for today, representing 4 different jurisdictions: United States of America, Ukraine, UK, and Switzerland. Let me briefly introduce each of the speakers. So first, Remy Gerber. He is a partner at the US law firm Moller Lamken. He is an international arbitration lawyer whose practice focuses on cross-border commercial disputes, international investment disputes, as well as related litigation. He is trained in the UK, US, France, and Switzerland. He represents clients across various sectors, and he has experience in ICC, LCA, UNCITRAL, Swiss Chambers, DIAC, EXIT arbitration. Remy holds a permanent academic appointment at the University of London, Queen Mary, where he is a director of an LLM program in arbitration. He is also former deputy registrar of the LCA and the author of the leading treatise on the LCA arbitration and arbitration institutions. Our next speaker is Irina Moroz. She is a partner at the Ukrainian law firm AGA Partners. She is a recognized expert in the field of international arbitration, international trade, and litigation. She is a member of the Chartered Institute of Arbitrators and a deputy head of the International Arbitration Committee of the Ukrainian Advocates Association. Irina has extensive experience in dispute resolution, including handling of complex commercial arbitrations and resolution of trade and maritime disputes. Irina has wide experience of recognition and enforcement of arbitral awards in different jurisdictions, including Turkey, Switzerland, Hong Kong, Russian Federation, Georgia, Egypt, and others. Going to United Kingdom, we have Tatiana Nesterchuk. She is a barrister from Fountain Court Chambers. She has been practicing as a barrister in England and Wales for over 15 years. She regularly appears as an advocate in arbitrations and the English courts, in all instances from the High Court to the Supreme Court. She also has extensive experience in sitting as arbitrator, so she knows the rules of the arbitration games both from the trenches and as an arbitrator. Her expertise in general commercial arbitration litigation with a special focus on fraud and asset recovery. And from Switzerland, we have Gabriel Natherbas. She is a partner at the Swiss law firm Homburger in Zurich. With over 20 years of experience, Gabriel has acted as party counsel, arbitrator in numerous international commercial arbitration proceedings, ad hoc institutional. She also regularly represents clients in investment treaty arbitrations and complex cross-border litigations. Gabriel served as president of the Arbitration Court of the Swiss Chamber Arbitration Institution, SCI, from 2016 to 2020. She is a board member of the Swiss Arbitration Association, ASA, member of the LCA Court, and the co-chair of the ICA-ASIL Task Force on Damages International Arbitration. Gabriel also received the Client Choice Award 2020 in Switzerland in the category Arbitration ADR. So in order to make today's sessions more interactive and interesting, we decided to prepare a case study and run it across 4 different jurisdictions to see how it will play out. So the case is quite simple. There is a pending commercial arbitration between 2 parties, a seller and a buyer, under an M&A transaction. The seat of arbitration is in Ukraine, and there are uncooperative witnesses in all of 4 jurisdictions: the US, Switzerland, UK, and Ukraine. And there are also documents which might be relevant to the case, material to its outcome, also held by one of the parties or a third party in the US, Switzerland, the UK, and Ukraine. And before we discuss and go on with each of the jurisdictions and potential measures in support that could be obtained in different courts, we would like to run a poll with the audience and ask the audience the question: do you find that court assistance in taking of evidence in support of arbitration is useful? So please use the QR code and vote. We will give a minute and a half for this process to be completed, and we'll then proceed with our discussion. Okay, we have a live update to the voting results. We will wait just a bit to maybe gather some additional votes, but preliminarily we see that we have more votes for yes, that audience thinks that it is indeed useful, than no. We will try to run the same poll at the end and see whether there is any difference in the opinion from the audience. So thank you. I think we can switch on to the discussion. And we start first with United States. And the first question is to Remy. Is it generally possible to even obtain this support from courts in your jurisdiction in support of commercial arbitration?
Well, Alexander, if we take the specific case study that you've described a minute ago, which is really a commercial arbitration between 2 parties, you described an post-M&A dispute, the short answer is, in America, it depends. It depends on what courts you're going to approach, which jurisdiction within the US you're going. I think a lot of us will know, there is a provision under US law. It's called Section 1782. It's Title 28 USC Section 1782, which allows a US court to order a party that's residing within the court's jurisdiction to provide discovery for use in proceeding before a foreign or international tribunal. And so that's a very powerful tool which allows parties, litigants outside of the US to try to leverage the very broad discovery system of the US courts in support of foreign court proceedings, for example, but also in support of investment treaty arbitrations. Right now, there is a measure of uncertainty in the US as to whether or not that Section 1782 should be available in support of private commercial arbitrations. And so that's why I said it depends. There are certain circuits, so certain federal courts in America, which have found that Section 1782 can be relied upon by foreign litigants in support of a private commercial arbitration like the one that you just described. But there's other circuits, so other district courts and appellate courts in the US that have found that Section 1782 should not be available in support of private commercial arbitrations. The reason for the split is really because of the wording of that provision of US law, Section 1782. It relates, as I said, to discovery in support of a foreign or international tribunal. And so some have argued that foreign tribunal or international tribunal does not cover a purely private commercial arbitration. So there's a split at the moment. The good news is that the split is likely going to be resolved before the end of the year, because the US Supreme Court has accepted to look at this issue in a case called Servotronics against Rolls-Royce. The case is pending before the US Supreme Court. It's been partially briefed, and I understand that we should expect a decision probably by the fall or by the end of this year. And so we'll know for sure whether or not 1782 is available to support a private commercial arbitration. But really the short answer to your question is we do have in the US a specific provision that, theoretically speaking at least, allows foreign litigants to come to the US and ask the US courts to force a party to either provide documents or testify in support of court proceedings that are taking place outside of the US. And so it's a very powerful tool, in theory at least. And as somebody who originally comes from a civil law jurisdiction, albeit I've been practicing in common law jurisdictions for 15 years, it's really something that's on paper very attractive if you're litigating outside of the US, especially in Europe, in Eastern Europe, in the former CIS region, etc.
So as I understand, Remy, there were successful cases where the parties were in position to actually get the support.
That's correct. Yes, there's been a number of cases in the US, and it's quite common to make a 1782 application. It's something that firms often are asked to help with. My firm has certainly been involved in a number of 1782 applications. So it's not something that's just on the books. It's a provision of US law that is actually applied in practice very regularly, with the caveat that I gave you, Alexander, which is that at the moment there is a split between different federal courts in the US as to whether or not you can use this for commercial arbitration. But yes, it's not just on the books, it's being used all the time.
So going to the next jurisdiction, UK, Tatiana, could you let us know what kind of support, evidentiary support, could be sought from the courts in UK?
Okay, so very quickly, UK courts are able to offer the parties support, although they do operate under the general principle of non-intervention. The kind of support that they can offer is, there are only two sections of the Arbitration Act which you need to be aware of. That's Section 43 and 44. Under Section 43, they're slightly different. The court can secure attendance of witnesses to give evidence or to produce documents. And under Section 44, the court can help with the taking of the evidence and with the preservation of documents. There is no general power of ordering disclosure. So that's probably it in the nutshell. Both sections are subject to conditions, slightly different, but both sections have the same basic condition, which is that there must be either a permission of the tribunal to make the application to court or the agreement of the parties to the arbitration. So that's the basic condition. That's probably it from the UK's perspective.
Thank you. And this leads me actually to another question about who can actually apply to the court. So is it the tribunal itself? Is it a party? And should some preliminary agreement from tribunal be sought? And Gabriel, could you comment on that from Swiss perspective?
Yes, thank you, Alexander. Let me first tell you that Swiss state court assistance was always available. We had, however, a big distinction the way you had to proceed when it came to Swiss seated arbitrations and arbitrations with a seat abroad. Swiss seated arbitration, there already before arbitral tribunal and parties could apply directly to state court. Before the beginning of this year, however, such a possibility was not available, and if a foreign seated arbitration wanted to get access to Swiss courts for assistance in evidentiary proceedings, they had to go over the judicial assistance proceedings, very burdensome, the Hague Convention on the taking of evidence, or bilateral agreements. Now, as the beginning of this year, a new article was introduced in the Swiss International Private Law Act, which now allows also for arbitration proceedings seated abroad to directly access Swiss state courts. So who can do that? It is either the arbitral tribunal, who could apply directly to the court at the place where the taking of evidence should take place, or a party. If, however, a party is trying to resort directly to the state court, it needs the approval from the arbitral tribunal. This also from a practical perspective, because in many arbitrations, if they would do so without the approval of the tribunal, there's quite a risk that the tribunal would not allow the evidence so retracted to be introduced in the arbitration proceedings. So this is more or less an answer to your question, Alexander.
Thank you. So, and is it maybe different in any other jurisdiction? Whether it's the same approach that the standard, the default rule is that it is the tribunal who can do this, and the other rule is that a party, but with tribunal permission.
So in the US, the position is interesting. It's any interested person is permitted to submit an application under Section 1782 for discovery. And so what it means is, first of all, it doesn't have to come from the arbitral tribunal itself. In fact, it would be incredibly rare for an arbitral tribunal to be the applicant, the petitioner. Second, a party doesn't even need the permission or the authorization of the arbitral tribunal before making an application. So any interested person can make an application. And so, of course, the parties to an existing or forthcoming international arbitration would likely be interested person, but there's also the possibility that a non-party to an arbitration who's nonetheless interested could potentially seek discovery under Section 1782.
I mean, Remy, you are totally right. This is the same here, but just let me precise, and I think that problem exists all over the world, Alexander. If you would, without the approval of the tribunal, go and solicit evidence and you try to introduce it in the arbitration, it may not be admitted. And I was, in fact, also once a party counsel in an arbitration where exactly opposing party has done so, and the tribunal has then not admitted that evidence, also saying clearly it was a circumvention of the procedural orders they have taken in place and put in place with regard to evidentiary proceedings. But it's an interesting question, and there is also one interesting decision from the Swiss Federal Supreme Court, who has actually supported an arbitral tribunal not allowing to let such evidence to be introduced, because it says at the end of the day, it's not a blatant violation of a right to be heard if the tribunal had good reasons for not allowing a party to solicit in such a way evidence and try to introduce it to arbitration, which otherwise would not have been available to such party in the jurisdiction where the tribunal was seated.
So just quickly adding, in the UK, it's only the party to the arbitration who has the right to make the application to the court to ask the court's assistance. So, and in very limited circumstances, generally, depending what you're asking for. If you're asking for to secure an attendance of a witness at a hearing, then it doesn't matter where the arbitration is seated, but the witness must be located here in the UK if you're asking the English courts for assistance, and it's in respect of proceedings also conducted here in the UK. It's just the logistics. So yeah, it's only the party who can do it. Certainly not under the Act. The Act doesn't permit the tribunal or the third parties to do the applications.
Thank you, Tatiana. And then a question to Irina. Is it possible to apply in Ukraine to the court for such measures? And if yes, is it possible to do it after commencement of arbitration or even before?
In the meantime, Alexander, so in the US, it's you can, what's very attractive is you can make your Section 1782 application even if your proceedings have not yet been commenced, and even if they're not even imminent. It's possible to make a Section 1782 application as long as you can demonstrate that proceedings are reasonably contemplated. So, for example, in an arbitration, if you send a notice of disputes before you actually file your request for arbitration or notice of arbitration, you could probably do your discovery request before the arbitration starts.
And do you have to give to the court some undertaking that you will commence arbitration within like a couple of months or something like that?
So I'm not sure that you have to give the equivalent of a solicitor's undertaking.
Okay. Irina, what is your position? What is the position in Ukrainian law?
Thank you. And do you hear me now?
Yes.
Yeah, great. So basically, my answer is closely related to the previous question: who has the right to make such application? And basically, Ukrainian law is designed in a way that it is possible to make our application and to seek assistance from the court only after commencement of the arbitration, because such application can be made either by the arbitral tribunal directly or by the parties with the consent of the tribunal. So in order to make such application, definitely you should prove that you have ongoing arbitration that is seated in Ukraine or otherwise abroad. Ukrainian law allows to make such application in support of Ukrainian seated arbitration as well as arbitrations that are seated abroad. The problem with our legislation is that we do not have a specific and detailed procedure regarding the form of this application. And that's why in practice it raises numerous questions, because Ukrainian court is very formal and Ukrainian courts are not very well informed about the different arbitration institutions abroad. Of course, when they will receive a certain inquiry or application from foreign tribunal, first of all, they should be persuaded that this tribunal exists, that there are certain arbitration rules, and that Ukrainian court has power to assist this particular tribunal. That's why our recommendation would be to make such application as detailed as possible, describing the name of the parties, the essence and the substance of the disputes, to provide maybe arbitration clause, an arbitration agreement, and maybe certain arbitration rules, in order to give the necessary basis for Ukrainian court to accept application and then to proceed with its consideration.
So, Irina, then would it not be better for a party to actually make application, because a party could explain all these details? And I see quite potential problems with tribunal being represented somehow before Ukrainian court.
Yes, you are quite right, because we have issues regarding representation. In order to make any application to Ukrainian court, the first step is to prove that you are authorized. And you should have power of attorney or specific agreement and engage advocate in order to represent you. So, of course, in practice, I see that it will be quite complicated for the tribunal to make direct application. So, most probably it will work if application will be made by the parties, and the party will provide a confirmation that tribunal gave consent to such application, because it will be easier in terms of proving representation and in terms of putting all necessary documents to the court and supporting such application.
And in terms of basically the forms of support, is it the same as another jurisdiction? So it's possible to question a witness and request production of documents, right?
Yes, you are quite right. In Ukraine, we can request disclosure of documents, preservation of evidence, witness examination, and examination of evidence at the place of their location. And we have a strictly defined jurisdiction. So basically, the competent court will be the court of appeal at the place of location of evidence or at the place of residence of witness.
Thank you. So now going back to our case study and what we discussed at the start, we have these 4 uncooperative witnesses in each of the jurisdictions. And let's try to explore what is actually possible to do in respect of getting some evidence from these witnesses. So my next question is to Gabriel. So can this uncooperative witness in Switzerland be subpoenaed to appear before the court and give evidence? And how this process take place? Is basically this witness takes oaths? Is it potentially liable to criminal punishment for perjury?
Thank you, Alexander. Just one thing to add to Irina was interesting to listening to you, and I must say you have a lot of parallels to Switzerland. Also in Switzerland, the arbitration needs to be pending for the very simple reason that you have to show a necessity for the state court to assist. And coming to your question, Alexander, if a Swiss court is approached, it applies in general its own law. And interesting, only as of this year, the provisions now introduced in the Swiss International Private Law Act also leaves open the possibilities for new forms to be applied. And as you can assume, I mean, this is now a couple of months and we have no case law, so it's going to be interesting to see. That's important when I give you answers, because my answers I have drawn from what I think will be the practice and how it is handled in analogiam to what we have seen if a state court was approached with Swiss arbitration seated arbitration was in Switzerland. So now coming to your question. Here it becomes a bit technical because we in North Swiss state court proceedings, we make the distinction between a witness, which is a third party witness, and a party representative who would be summoned. And when it comes now to arbitration proceedings, both parties are deemed to have an obligation to appear in front of the court. But the court takes the view that if a party would not appear, then it is for the tribunal to draw the consequences, negative interferences, and it would simply state this party has not appeared. Whether when it comes to a third party, then the court would apply coercive measures such as invitations, subpoenas, invitations, and would force that party to appear. So we have these interesting distinctions whether it is a party or whether it's a third-party witness, which in my view makes practical sense because it is then truly for the arbitral tribunal to decide. And also, let's face it, from a practical point of view, the party will in all likelihood have to appear in front of the tribunal. So in practical, you will not see that. But if a party is then appearing in front of the court, then, Alexander, they are both admonished to tell the truth, and they will both be admonished that if they would not tell the truth, they could be criminally sanctioned, and that is in fact possible. And for both, whether for a party or third party witness, criminal sanctions could be imposed. Taking an oath is not common in Swiss civil procedures, and as such, with this possibility to actually admonish them and threaten them with punishment, it is also not necessary. So you would not see witnesses taking an oath. This is not familiar in Swiss civil proceedings and would not be taken place and is not allowed.
Thank you. And now getting a bit even more technical into actual process. What happens when this witness comes to the court? Question to Tatiana. So what procedure in examination of witness should the court follow? Will the judge put questions to a witness, or are the parties or maybe even the arbitrators allowed to also attend this hearing, take part in this examination and also put questions?
Apologies. Can you hear me now?
Yes.
The way the procedure works in England is that the only thing that the court will do, it will summon the witness under Section 43, or it will require the witness to give evidence by means of a deposition under Section 44. And so, the only thing the court will do is issue the order requiring the witness to come and give evidence. That is it. So that's the role of the court. The court will not be asking any questions. When the court issues summons, it has to be in relation to a witness located in the UK and also in respect of proceedings in the UK. So what happens when the seat of the arbitration is outside the UK is normally a hearing is set up, in any building, in any room. It could be in barristers' chambers, it couldn't be in the ICC court, for example. A hearing room will be set up, and usually where the arbitration is seated somewhere else and it might not be convenient for arbitrators to travel to another jurisdiction, to the UK, there'll be a video link, for example. And it might be, and somebody will be at the hearing, in order to take an oath for the witness and to help the witness. And the questions would generally be asked by an advocate. So the party who wants to call the witness will be asking questions of the witness. And then the other side, well, it depends on what the procedure is at the seat of the arbitration. I mean, if this was in England, then the other side would be entitled to cross-examine. And of course, the arbitral tribunal would be entitled to ask questions. So that's the hearing. If we're talking about a deposition, that is again a procedure which will be set up anywhere, really. It could be in lawyer's office, and both parties will be entitled to take evidence, and a note of that deposition will then be taken and presented to the tribunal. So those are the two different procedures that could be used.
So in terms of a court hearing, the court more or less performs some administrative function, just asking the witness to appear, and more or less then it's the same as at any other arbitration hearing.
Absolutely, that's exactly right. The court, there will not be a court hearing in terms of listening to the witness. The court will simply grant the order or not grant the order, issuing the summons, and so you will have that sanction. So if the witness doesn't appear, there will be that sanction of the court, the criminal sanction, that if you are disobeying the order of the court, you're in contempt of court. So that's one of the advantages of going to court. If you have a reluctant witness, I think you have to be very, very reluctant and very brave to disobey the order of an English court.
Thank you. And is it any different in maybe other jurisdictions?
Yeah, I was just about to comment. I was just about to comment. It's really interesting to hear Tatjana, because in Switzerland it's totally different. We have a very strict system. In ordinary Swiss court proceedings, you're not allowed to approach a witness. So you're not even allowed to prepare a witness or inform the witness what they would be supposed to testify. Just simply offer the witness. And so when the state court is actually asked to provide assistance to arbitration proceedings, they are totally unfamiliar with the usual practice how arbitration proceedings are conducted. And that's why, in all likelihood, what I have seen before, very limited, even for Swiss-seated arbitration, is that the court will, of course, ask for a list of questions. And as it is normal in Swiss civil proceedings, it is the judge who will simply ask these questions, then they are minuted, and this record is done. Now, however, it's going to be interesting with this newly introduced article, and I think we will see judges who may apply more flexibility and use their discretion that they have now, and may even allow, in fact, that additional questions are spontaneously asked by parties or even a tribunal, and we may come also to the topic may even allow, for cross-examinations or other forms which are totally unknown in ordinary Swiss state court proceedings. So basically, contrary to you, Tatjana, you have the typical Swiss courtroom and the rules that apply in a Swiss courtroom that will dictate this assistance proceedings.
Yeah,
I'm sure. Is it probably the same in Ukraine? Is it a civil law country?
Yes, basically Ukraine has very similar position to Switzerland. So basically you should expect to have like a formal hearing, because of course our judges are not familiar with the international arbitration institution, and don't be surprised if they will ask at the beginning what is LCAA and what is ICC, and you should explain that these are arbitration institutions seated in that or this country and so on. So you should be prepared that it will be like a formal hearing, and the court will be guided by the general rules concerning witness examination. So, of course, at the beginning, the court will inform the witness that they might be contempt and they might be a criminal responsibility in case they will give false or untruth statements. And the court will ask the questions that were prepared by arbitral institution or arbitral tribunal. There should be a list of questions prepared. So the court will not put the question on its own. And our civil procedural code provides that the parties to the arbitration proceedings have right to be present during the hearing and to put questions as well. Interesting thing that our code does not provide that arbitrators or representatives or arbitration institution have right to be present. So this issue is silent, and most probably the judge will only ask the questions that were put in a written form by arbitral tribunal or by the party, and the parties that will attend the hearing will be allowed to ask the questions as well.
Thank you. And Remy, what is the approach in the US? Is there some kind of list of questions, or is the system similar to UK? And if yes, what are the regular rules for examination of witness?
Sure. So I think the system under section, the process under section 1782. So again, with respect to seeking discovery in support of foreign proceedings, is not very different from what Tatiana has described with respect to England and Wales, in the sense that the testimony of the witnesses would be taken in the form of depositions. Questions would be asked by the petitioner's attorneys directly to the witness in the absence of a judge, not be taking place inside a courtroom. The judge would not be asking questions. There would typically be a court reporter who would first administer an oath for the witness and then take a verbatim transcript of the testimony, which could last multiple hours if you want. And so the short answer, you asked about the rules. Typically, the rules that would be applied would be the federal rules of civil procedure, which are the traditional rules applied in a federal court litigation, if you want, in the US. So there would be no hearing. It would be really deposition. An interesting thing also to note is that because you don't have a judge present during the deposition, the attorneys don't have as many opportunities to object to a certain line of questioning as they would do in the US courts, where the rules of evidence would apply and they'd be able to raise objections to questions. The only sort of objections that you typically raise would be about privilege, if a question would force somebody to breach an attorney-client privilege. But otherwise, there's much leeway for the questioning attorney.
So as I understand that at the end you have this deposition in form of this minutes prepared by the court reporter, and this is the document that the party can potentially use in arbitration proceedings.
That's correct, but it could also be video recorded in some instances. So you could also have a video potentially of the deposition. It's quite common.
Mm-hmm. Thank you. And then question to Irina again. In the Ukrainian proceedings, in civil law proceedings, what is the outcome of this whole examination of witness? Does the judge prepare some document or maybe ruling? What happens next, and who receives the result of this examination?
Generally, it's a very interesting question, because Ukrainian law is silent on the form of document that should be prepared based on the outcome of witness examination. as well as the law is silent where to send this document and who is entitled to receive this document. So my view is that Ukrainian court will simply be guided by the general provisions of the hearings and will prepare minutes depending on the outcome of examination that will contain the general course of the examination. And I think that the court will be guided by Article 250 of Civil Procedural Code of Ukraine that obliges the court to execute minutes concerning the separate court actions that were made beyond the court hearing. And of course, such minutes should include the names of the parties, their details, the general descriptions of the questions that were asked and the answers that were made. Of course, the problem might be that such minutes sometimes are very general. So it is not efficient, and sometimes it is very unhelpful because you cannot get into the details of the answer of the witness. Mm-hmm. And in such situation, it might be helpful to have audio recording. Under the general rule, all court hearing should be made with the audio recording, and the parties have right to ask the court to provide them with a copy of audio recording. So it will be advisable for the parties after completion of the hearing and before even the hearing to persuade themselves that the court is arranging audio recording. After completion of the hearing, request the copy of this audio recording from the court and to receive the minutes of the hearing concerning the witness examination. Of course, court hearings are not similar to arbitrations, for instance, where you can have a private transcriptors that will put in the details word by word everything that was said. In Ukraine, it is basically impossible. From my experience, I have never seen such a request to be made. So if you make such application, you should take into account that most probably, even if you will ask the court to make your own personal transcript, Ukrainian court might reject. Otherwise, please be sure that Ukrainian court will make audio recording and you have a right to ask this audio recording from the court. Concerning the persons...
So I assume that you can just take this audio recording afterwards and make your own transcript.
Mm-hmm. Yes. So that might be the way out from this situation. And of course, under the default rule, the parties that participated in the hearing, they will be entitled to receive the copy of the minutes. So they might come to the court and to get the copy, or ask the court to provide them with a copy of these minutes of witness examination.
Thank you. So I think we've established that in every jurisdiction it is indeed possible to ask the witness and subpoena the witness to appear, take this evidence and use it in arbitration. If we then turn to the second big portion of our case study, the documents that are held in each of the 4 jurisdictions. Starting from Tatiana, could you let us know, is it possible in general to request this party to produce documents that are held in its possession and control?
So the court usually will not be ordering disclosure in support of arbitration. That is reserved to the tribunal. What the court can do is it can order a witness to produce certain specific documents. So you can make an application under Section 43 for summons to a witness, and it could be that that witness is summoned not to give evidence, or not just to give evidence, but also to produce documents. But what you have to be able to do is specify in your application exactly what documents you're seeking. Sometimes you can describe them by class, but usually in order to succeed, you need to explain what document it is that you want the witness to produce, because the court has to be very clear in the order what the witness has to do, and the witness has to be clear from the order what he has to do or she has to do. So you have to specify the document, and you have to explain to the court why you believe that this witness has that document. So that's one thing that you can do. Another thing that you can and this is usually a third-party witness. The only thing the court can order the parties to do is make an order under Section 44 to preserve evidence. So if you're worried that a party, your opponent, might be destroying some documents, you can come to court and you can ask the court to make an order for preservation of evidence, preservation of documents. But the court will only make this order if the tribunal has no power to do this, or for the time being cannot act effectively. So that usually would be the case where the tribunal hasn't yet been constituted. But even then, there is a kind of interesting debate at the moment whether the availability of emergency arbitrators is in fact sufficient to make sure that this condition that the tribunal is not able to act effectively is not complied with. So there has been cases where the court held that availability of emergency arbitrator powers under the LCIA rules meant that the court has no jurisdiction to make any orders at all under Section 44. There was one case, though, quite recent in the commercial court, where the court said, well, I have evidence it will take about 11 days for emergency arbitrator to be appointed, and I really think that this order for preservation of documents is very urgent, so I'm going to make that order. So it all depends, is the answer. And the more evidence you can provide as to why your case is urgent and why the court should be ordering you, giving you this order that you're asking, the better the better chance of success you will have.
Mm-hmm.
So
thank you. So, just to let you know that we started already receiving some questions. I suggest that we deal with them at the end because they already relate to the previous topic that we discussed, witnesses. So I suggest we proceed with documents and then have some round of questions from the audience at the end, covering all topics. So thank you, Tatiana, on the approach of UK courts. I would now like to ask Gabriel, so what is position in Switzerland, and is it possible to ask the court to order production of documents by a party in a situation where such documents are held by this party in different jurisdiction, not in Switzerland?
Thank you. I was actually pleased to see that finally I found some, let's say, similarities also with common law jurisdictions, Tatiana, because also in Switzerland, and this is also the case if you ask for witnesses to appear in front of court, you always have to show a necessity. You have to show that the arbitral tribunal is legally not in a position to do so. There is possible simply means really legally in a strict sense, the arbitral tribunal not gather that evidence itself, or whether already geographical distances or other impediments may be sufficient. When it now comes to the documents, yes, the short answer is yes, because the state court who can be asked for assistance in evidentiary proceedings can apply all means it would have in ordinary state court proceedings, and the order of for documents is also an available mean, and that means that it could do so. If a party in a tribunal, however, approach the court and they ask them to order a document, they have to show that such document is relevant and material, because the Swiss approach to document production is far more narrow than in the common law jurisdictions. So they will definitely check whether this is necessary. And that is, of course, even more strictly applied if you would ask the production of a document from a party who would not be in a possession of such document, which is, however, possible. What you would have to show is that that party, where the document is not in the jurisdiction, but what you would have to show is that the party actually is in possession of such document. That means that it is for the party not unduly burdensome to get hold of the document. So theoretically, you could ask from a party, a third party, to produce documents. If you show that the tribunal cannot do so, that such documents are material and necessary for the outcome of the arbitration, and that that party is in a possession, has access to, and that would even apply if that document would not be in the Swiss jurisdiction, but you can show that without undue burden, not too much efforts, etc., that party could produce that documents. You would have, the same applies if they have to appear as witnesses, you would have to reimburse them with reasonable means for any efforts and costs they would have, or the time they have to spend for producing these documents or for appearing to court if they come as a witness. That's the answer.
That is very interesting. Thank you. And we now come to US, and the question to Remy is, can the court order production of documents not from a party, but from a third party?
Yes. And to answer also the question before, Section 1782 also requires the target of your document request to provide documents even if they're located outside of the jurisdictions. The requirement is only that the target, the witness, be found or reside within the jurisdiction of the court, but not the documents themselves. So that's the short answer. And yes, the process under Section 1782 allows a U.S. court to order discovery from any person or entity who resides again or is found within the court's jurisdiction, regardless of whether or not that person is a party to the arbitration or a party to the arbitration agreement. But there is a caveat, and that is that the notion of residing or being found within the court's jurisdiction is one that has been interpreted slightly differently by different courts in different circuits in the US. And so, for example, there is, I believe, in the Fifth Circuit, which includes, in particular, Texas and Louisiana and Mississippi, that there is case law that suggests that for a company to be found or in that jurisdiction, it's enough for the company to have some sort of office. There's case law that suggests that. Now, in the Second Circuit, by contrast, which is important because it includes New York, in the Second Circuit, I think there's some recent case law from 2019 that suggests that for a company to be found or to reside within the court's jurisdiction, it needs to either be registered locally or it needs to have its main place of business locally, or if not, it needs to have minimum contacts with the jurisdiction, but these minimum contacts need somehow to be connected to the evidence that you're seeking. So it suggests that a Ukrainian company that would have a small office in New York with limited activities and which activities would be unconnected with the evidence that you're seeking to obtain, that might possibly not be enough in some parts of the US, at least in the Second Circuit. That's my understanding. But the short answer is yes, you can get documents regardless of where they're located, and yes, you can get them from individuals and companies that are not parties to an arbitration or to an arbitration agreement.
Thank you. And is it any different in other jurisdictions, Ukraine, UK, and Switzerland, the position in respect of third parties?
No, also we also can get documents in possession of third parties. And let me also add a practical point of view. This is going to be the practical relevant question, if you can do that. Because if you ask documents from the party, the tribunal will hardly ever allow and not itself resort to complex state court assistance proceedings with foreign state courts, because it has additional means itself, drawing negative interferences, etc., if a party would not produce the documents. So the practical relevance is truly in making sure a third party could be coerced to produce documents.
From the Ukrainian position,
Irina,
generally, that it is possible to request the court to product the documents from a third party, but in practice, the burden of proof is very high. So you need to prove that, first of all, these documents that the third party owns is really very important for the case. It is impossible to continue the hearing. And of course, here you could face certain complications because the case is under consideration in arbitration, and you are making the request at the Ukrainian court that is not familiar with the substance of the dispute. So theoretically, it is possible to make such application, but in practice, you should persuade the court that it is necessary
to compel the third party to produce the documents or evidence in support of arbitration.
So
Thank you,
in the
Tatiana.
UK, there's actually been a recent decision in 2020 by the Commercial Court, and then it was reviewed by the Court of Appeal, which said that Section 44 powers, which effectively the powers to take a deposition and to order preservation of evidence, can only be applied to the parties to the arbitration. So when you're asking for preservation of evidence, it looks like you can only apply for an order against a party to the arbitration. Now, it might be that this case will be reviewed because the Commercial Court said the entire Section 44 is limited to parties to arbitration. The Court of Appeal actually disagreed and said that the section dealing with the taking of evidence can apply to non-parties because it refers to witnesses. And a witness must mean more than just a party to the arbitration. Witnesses must include third parties. But the Court of Appeal thought that the rest of the section would only apply to parties to arbitration. So I think that particular issue is still up for grabs because actually that case really only dealt with the taking of evidence and not with the issue of preservation of documents. So the comment by the Court of Appeal is strictly obiter and not binding, but that's the law as it stands at the moment. But of course, where you are getting witness summons for the witness to come and give evidence and or provide documents, that can be that order can be obtained against a non-party.
Thank you, Tatiana. And now question to Irina of a more general nature. Are there actually many cases in your jurisdiction in Ukraine dealing with this request to the courts to obtain this support? And have you dealt with any of them yourself?
So I will start from the second question. So in our experience, we have never made application to our court in support of arbitration. The reason why we did not pursue this measure is that because we did not have such necessity. Because usually we have different alternative methods to collect the documents, like advocacy requests that we can send and use in Ukraine in order to collect necessary evidence. But of course, in case we would understand that there is no other option to examine the witness and to collect the evidence, so we will try it. Concerning the number of applications, I think that in reality there are few. And the reason is that we do not have a very well drafted law that provide the detailed description how the applications should be made, how it should be considered by the court, what is the timing of the court to consider such application. And in practice, the parties sometimes do not want to make such application because they understand that it would only delay arbitration proceeding, because there are no time limits for Ukrainian court to consider such application. And usually the parties elect different ways to collect the evidence. In practice, there are some cases where the parties tried to make some application, but it was made more in order to delay the proceeding or to use some kind of guerrilla tactics. So generally our law, of course, need to be modernized and need to be amendment in order to provide a more effective procedure to make such application and collect evidence or examine the witness.
Thank you, Irina. And actually, based on your answer, I think maybe a very important question to all the participants. Is it really efficient way to gather evidence? Is it something that you would recommend a client to pursue in real life arbitration with strict deadlines?
Can I go first,
Sure,
Alexander? Thank you.
Sure.
I think generally, sometimes when you have an uncooperative third party, making an application to court would be the only way you can obtain documents or evidence from that third party.
So if you are dead set that this, you know that this particular person or company has the evidence, and you need that evidence, and that might be the only way. How long will it take in the English court? Actually, because these applications tend to be incredibly focused, I would only recommend making them if you're absolutely sure what documents it is that you need, and that the party in question holds them. So, for example, it might be company accounts or something like that, or company banking details, banking records, what payments they've made. So that's the kind of thing that I'd normally apply for. You can make the application to court, and the court can actually be very quick to resolve that application. It's a fairly simple application. In the English commercial court, we have the Friday applications list. As long as your application is less than half a day, you'll be in the Friday applications list, and the court will usually make a decision there and then. So you're in court, you make your application, and the court gives you the ruling, and you get your order the next day or as soon as you can draft it. And so then it is up to you what you do with that order. Whether or not that order is of any use is another question. So how long then it will take you to enforce that order, that's another thing for you to consider. And another thing to think about is if the court refuses, then you think, well, is it worth going on appeal? Because of course, any appeal will take some time. Going to the Court of Appeal, we don't have any deadlines for judges to produce judgments. It's just as a matter of practice, I can say that if your application is short, you will get your order on the day you make the application. When you get to appeal, the Court of Appeal, it operates how it likes to operate. If your matter is really quite urgent, so you're talking about somebody possibly destroying evidence, then you can ask for the Court of Appeal to hear it urgently, and they will accommodate you. I mean, I've had a hearing in the Court of Appeal at 6 o'clock in the morning because our application was that urgent. So you can get swift justice in the UK courts, but if there is no urgency, then I'd probably say it might not be worth it if you're going to appeal.
Can I
Thank you,
also
Gabriel,
quickly step in? Yeah, Alexander. I think I would say my over 20 years of experience, I have only 2 cases where I could see that such resorts to state courts have been used, and it's really very rare. In Switzerland, I cannot give you a statistics because the law for arbitration seated abroad is totally new, and also before they did not distinguish between judicial assistance proceedings or the Hague Convention in the statistics published and truly direct support requests by arbitral tribunals seated in Switzerland. But my short answer, or try to be as short as possible, is as follows. I think for witnesses, I would really think 3 times before I would ask and go for this burdensome and still time-consuming proceedings, because we all know in many jurisdictions and also in Switzerland, it will simply be that the list of questions will be submitted, and then the judge may just simply read out. So if I would go for such state court assistance, and I'm glad that it exists, then it is exactly what, like Tatjana has now pointed out, it's very limited cases where you really know such documents exist. The parties to the proceedings really are not in possession of these documents, and these documents are absolutely crucial for your arbitration proceedings. I think then it may be worth, because we all must understand it will lead to a suspension of the arbitration proceedings. It will take time, although now in Switzerland I'm very positive that it will take much less time, as you can directly go apply to the judge can directly apply its own law, etc. But it will take time. And so you must have really compelling reasons to do so.
Thank you. And Remy, what about US?
Yes, I think Section 1782 can be a game changer in many international disputes if it's available to you. And that could be a big if when you're talking of a commercial arbitration, like we said. But if it's available, it could really be a game changer. Because as I mentioned before, you can make your 1782 application before your arbitration has started, such that the timing would work potentially nicely with the arbitration. Second, because when you're seeking information from certain very large companies that are often on the receiving end of 1782 applications, they have a process in a place. They have lawyers that are used to dealing with these applications, and often sometimes you can negotiate a scope of testimony or documents and get that without having to necessarily litigate it. And so it could be done relatively cheaply and relatively quickly. I mean, it can take as long as, I understand, as a year and a half if you have appeals, etc. But it could also take just a few weeks potentially. So it could really be a game changer in a number of situations. For example, if you have a company that has a case that relies on showing that certain emails were sent fraudulently because the emails were sent not by the owner of the email account but by somebody else on their behalf, you could potentially do a Section 72 application against the company based in the US that manages or runs, if you want, the email service. There's some statutes that would prevent you from getting access to the substance of the emails, but you could not. Normally, you should be able to have access to metadata, including the location of the person, maybe the IP address of the person that sent the allegedly fraudulent email. And so that's a practical example of a case where you could really have a game changer. You could win or lose your case because of that. And the final point is that it could also help with the settlement negotiations. If you get access early on, it could potentially help you resolve the dispute before you have to go through the entire arbitration. So on balance, I think it's a great tool, and we look forward to hearing from the Supreme Court later this year as to whether or not this is available for private arbitrations.
Alexander, allow me just one caveat. Remy, I have been quite involved in a few arbitration where we also actively as counsel or where I was acting as an arbitrator was confronted with evidence that was gained through the 1782 proceedings. And as I have stated before, the big caveat I want to repeat again is you must make sure that you can actually use this evidence later on in the arbitrations, because I see a lot of arbitrators who are very reluctant then to allow such evidence to be submitted, because they say normally in our proceedings you would not have had the possibility to gather this evidence. And you will see, of course, also opposing parties heavily opposing. So as an arbitrator, I was every time totally challenged when I had to decide whether to admit such evidence gained. And as a counsel, I always had to advise the clients, let's go for it. It costs something. And I cannot even assure you whether we later can use it. But where I agree with you, Remy, it is a very interesting tool for settlement discussions, because the other party faces this uncertainty as well, and if they know you have this compelling evidence in your hands, it may move them. That's correct.
And it's a very good point, Gabriel. I agree with you. So a few months ago, I was at a meeting of the International Arbitration Club of New York, and we did a vote of the members on whether or not members thought that Section 1782 should be available to private arbitration. And I was surprised to see that it was fairly evenly split. I think it was something like 55% in favor, 45% against. And the thinking of people who were against the idea of using 1782 in support of foreign private commercial arbitration proceedings was precisely that you could argue that the parties, when they agreed to insert an arbitration agreement in their contracts, at least US parties, part of the reasoning was probably that they wanted to get out of the US court discovery system in the first place. So the fact that your discovery would not be available necessarily in arbitration, shouldn't it mean that the US court should not grant it? So that's, I think that's a very fair point, and it's one that's debated.
Many thanks. Many thanks to all the participants. These are very valid and reasonable considerations that each party should take into account before considering whether to actually use it or not. Unfortunately, we ran slightly more than planned. Therefore, we will not be able to have the second poll. But I imagine that it may have changed a bit, but overall, on balance, probably it is still something that is useful and the audience will support it. So we had one question, but probably we will not look into it. The question was which rules of procedure the court will use, whether its own or of the seat of arbitration. I think we covered it in all of the jurisdiction that the court will use its own rules of procedure. So with that, I thank all of the panelists. I think it was very entertaining and helpful discussion to really understand how this process works in all the jurisdictions. So many thanks to all of you. And I think we'll be now switching to the next panel.
Thank you also to you for being an excellent moderator and for this interesting session. Thank you.
Thank you.
Hello to everybody. This is Maria Hauser-Morel. It is now time for the debate. The topic of our today's debate is: this House believes that a presumption of arbitrations without hearings will make arbitration great again. And we have two excellent speakers, and I hope that they will soon join us. Hello, Noah. Hello, Patricia. And our two excellent speakers, they need absolutely no introduction. You have their bios in the brochure, but just very briefly, Dr. Patricia Shaughnessy is an American in Sweden. She's an arbitrator, counsel, and Noah knows where I'm getting, of course. And she's also created the famous Master of International Commercial Arbitration in Sweden. Patricia, we're very happy to have you. And against her, we have Noah Rubens, QC, an American in Paris, counsel and arbitrator and specialist, and very active in CIS. He's leads the Freshfields CIS Russia Dispute Resolution Group. So welcome to both of you. And so we have today an interesting debate between the two of you. This House believes that the presumption of arbitrations without hearings will make arbitration great again. And before the two of you start the debate, we propose a poll to our participants. And how it works is that you should either scan the QR code that appears on the screen or follow the link and vote. And we are to wait for some 1 or 2 minutes, and then the results should appear on the screen if I got it right. So we are waiting. Okay, we have one vote for now. We're still waiting. I don't know if the organizers see if the voting is still pending. Otherwise, I would announce the preliminary results. Okay, unless I hear objections from the organizers, the results from the first poll is that no is the majority. Now, I no longer have the results on my screen, so I think it was 11 for no. Yes, very well, Noah.
Phew.
I can hear you.
I'm like going,
I don't know if the others can.
Okay. Maybe I was screaming over you this whole time. Sorry.
That's what you usually do, don't you?
That's true. That's a good point.
Sorry, I no longer have the result. Yes, very well, Patricia. So I no longer have the debate. It was majority was no, but I think it was 11 for no and 6 for yes. But I don't have the results on my screen. But now it's time for the debate for today. And of course, it's a debate. So the views expressed by Patricia and by Noah are mainly for the purposes of this debate. So we have to remember that. But for the purposes of this debate, Noah will be for and Patricia will be against. And the structure of the debate will be that each speaker will speak for 7 minutes. Then afterwards, there will be rebuttals 3 minutes each, and then we will take the poll again. So Noah, as you are for, I let you begin. And
Thank you.
I
do hope that everyone can hear me. That was a little broken up. Can you hear me?
Perfectly well.
Can you hear me okay? All right, great. All right. We are at an existential moment, my friends. We are at a crisis of arbitration, a crisis that is caused by a violation of the very fundamental expectations of the parties who choose arbitration. Arbitration has always been a trade-off. It was never intended to be a full quest for justice at any cost. Otherwise, there would be appeals on the merits. There would be 6-week hearings like there are in the High Court in England. And nobody wants that. But the trade-off for partial justice needs to be reconsidered because we have lost the upside. What we're supposed to get in exchange for no appeals and so possible mistakes and so on is savings in cost, savings in speed, and a legitimacy born of the agreement between the parties. And I put to you that that is no longer the case. We have multiple 100-page briefs being submitted with dozens of witness statements and massive costs of counsel and an escalation of massive submissions where really very little would do, where issues even in cases where the issues in dispute are quite simple. And part of that problem is the assumption that there is always going to be a hearing. Hearings involve a massive preparation cost. It ties up the clients, it ties up their counsel for an extended period of time, as well as the arbitrators for that time. In my personal experience, up to 1/3 of the total cost of arbitration is incurred in the run-up to and during the hearing, as well as after the hearing, to the extent post-hearing briefs are required. That's with respect to cost. With respect to time, there's no doubt that the endless extension of time for the issuance of awards is partly because in every case, pretty much, there's a hearing. Because first, to find the block of time that everyone can, all of the arbitrators can accommodate and the parties and their counsel can accommodate, creates dead space in an otherwise condensed schedule. And that can double the total length of time of an arbitration. And the drafting of an award cannot begin until after the hearing has been held, and even if there's post-hearing briefs after that. And of course, all the material that was presented during the hearing has to be also taken into account in the award. At least it has to be mentioned, and that also adds to the time. And so you get months and months of additional time before awards are issued. And what for? Well, the main purpose of a hearing in arbitration is to hear witnesses. It's not to repeat the same arguments that were made in writing at length. And a great many commercial disputes involve no witnesses. Even for those cases, the presumption is that there will be a hearing. And the vast majority of cases, including those with witnesses, aren't decided based on what the witnesses actually say. Just think of the civil courts, for example, in places like Germany or France, where there are no hearings, there are no witness, there's no witness testimony at all, even in the most complex and important civil disputes. No one says that that deprives the parties of some fundamental right. Any civil judge will say, well, ultimately, the witnesses, when they come, they say what's good for their side. You can't trust them anyway. And so bringing them in front of a tribunal only confuses the issues. It only creates the opportunity for dissimulation, for false statements, and for distracting the tribunal from what's really important. There's also an even more nefarious point, which has to do with diversity, which has to do with unconscious bias. It's at the hearing that the tribunal can be subjected to their unconscious prejudgments about people's ethnicity, their national origin, their gender, their age, whether it be counsel or the attending representatives of the party. And that is an extremely nefarious thing, which does not come into play when cases are heard on the merits. Now, let me make clear, nobody is saying to eliminate hearings. Just shift the presumption. The presumption against hearings is already in place in fast-track arbitration. And what I'm saying is that this can have, shifting that into normal track arbitration can have a positive impact where on the margin, a great number of unnecessary hearings will be avoided. The cost and time of those hearings will be avoided simply because the parties will have to think twice as to whether it's necessary. Discretion will always remain with the tribunal, and in appropriate cases, the tribunal will hold the hearing. So 3 reasons, cost, time, and legitimacy, all point to a presumption against oral hearings in commercial arbitration. Thank you.
Thank you very much, Noah. You haven't even used up your whole of your time.
Excellent.
Patricia. Patricia, it's now your turn.
Thank you, Madam Moderator and Mr. Rubens and all of our esteemed colleagues who are listening today. The premise of the proposition, which Mr. Rubens has so eloquently presented, fails. So consequently, the proposition falls with it. The idea that arbitration needs to be made great again implies that somehow its greatness has been lost. That is simply not the case. Mr. Rubens paints a picture of a crisis. There is not a crisis. There is an evolution of arbitration expanding its toolbox, and it's expanding its responsiveness to the users. There is no evidence that users want such a presumption, and indeed the evidence points to the contrary. The evidence points to arbitration is great and getting increasingly better. The main features of arbitration, which have promoted it and made it the trusted preferred method for resolving business disputes, would be undermined by the proposition which is proffered by Mr. Rubens. The flexibility, the effectiveness, and yes, the efficiency, and yes, the lower costs, the fairness, and the respect for party autonomy would be thrown under Mr. Rubens' bus, driven by arbitrator discretion, without any directions to the parties as to how to overcome the burden of such a presumption. Now, indeed, there are many problems which this proposition would introduce, and I will come to that. But first, I would like to explore a little bit the failure of the premise. Mr. Rubens has helped me by noting that there already exists arbitration suitable for documents only, fast track, low value, less complex disputes, expedited arbitration procedures. And indeed, UNCITRAL Working Group 2 is nearing the conclusion of its work on proposing such features to be included in the UNCITRAL arbitration rules. Parties already can, and very occasionally do, subject their disputes to various documents-only arbitration by agreeing to expedited procedures or to rules which will trigger those procedures, or by putting it into their arbitration agreement, or through procedural agreements. Indeed, already the Chartered Institute of Arbitrators produced a documents-only procedure protocol, which parties can use if they would like. The UNCITRAL rules and Article 27.2 provides that this could be something the parties agreed to. And indeed, the UNCITRAL model law in Article 24.1 provides, subject to any agreement of the parties, the tribunal shall provide hearings as appropriate. The ICC Commission's widely read document on controlling times and costs provide in section 35 that this is something which can be considered by the parties of the arbitrators, and it's included in the ICC's appendix number 4. The tools are there if the parties want them. What Mr. Rubens is proposing is that there would be a presumption of this on all arbitrations, whether or not the parties agreed. And this would be to strangle the right to be heard, and it would be to harness and restrict party autonomy in favor of discretion of the arbitrators. It would throw the balance off. Let me quickly respond to some of the problems that will raise, but let me notice that arbitration hearings are not dead space, and to many parties, they're a valuable opportunity that parties want to have to witness, to see, and to hear the administration of justice in their case. The parties may not always only want to pay lawyers to make extensive submissions, which the parties do not find particularly easy to comprehend. They want to see the arbitrators in the eye. They want to hear what is being said in the proceedings. And for those who don't, there are the tools already available to have documents only. I would suggest that the approach of the Hong Kong International Arbitration Center in its Rule 24.2, I believe it is, that provides for, on the request of a party, an arbitrator can consider documents only, not a presumption, on the request can consider, is a good balance to approaching when a hearing is necessary or not necessary. We do not need, and indeed, the presumption that is being proposed would have serious problems. One, unlike what Mr. Rubens projects, it would likely increase written submissions because now everything would need to be in writing. There would not be an opportunity to meet with the tribunal, to have questions posed and easily answer them during the proceedings. Instead, there would be written questions and written submissions and counter submissions. The whole process would become writing heavy. There would be witness statements, and those statements would have to be cross-examined in writing. Again, more writing, more legal fees, and less opportunities for the parties to feel that they're able to participate in the justice system which they're financing. And by the way, as the lawyers are writing all of this material and the arbitrators are reading all of it, in the ad valorem system, the payments would probably not be any less, but for the arbitrators, you wouldn't have to go to a hearing. You'd still have to write the award. There would be serious potential enforcement issues because indeed the model law and most modern arbitration acts provide for the right to a hearing, be it live, in person, or remote. This could raise particular issues about due process. And it would be contrary to user expectations. As mentioned, we have already the tools, and we don't see them, except in the fast track cases, being used. It arguably would favor civil law jurisdiction.
It's time to conclude, Patricia. It's time to conclude.
I have so many more arguments. I'll save them for the rebuttal.
Thank you. Noah.
Thank you. Well, we see the difference in approach between the academics and the practicants in terms of the use of time. I do put to you that there's a crisis in arbitration, and anyone who has seen the inflation of costs and the complaints of clients will understand that there is something broken here. Now, my learned friend has presented a straw man to you. It has nothing to do with what I'm proposing. I'm by no means proposing to do away with hearings. I'm simply proposing to shift an assumption. That means there will still be many, many hearings in many, many cases. And such things, as Professor Shaughnessy has pointed out, happen all the time in fast track. And so this idea that national arbitration laws somehow prohibit or will not recognize an award where there wasn't a right to a hearing, I think is a fallacy, because we know that fast track awards are entirely enforceable around the world. That is not a problem. I also think that this idea that focusing on the writing rather than on the oral advocacy would somehow increase the writing. I don't think that's true at all. On the contrary, this idea that one can throw anything at your opponent during a hearing, regardless of what was written, is what increases the complexity and the unpredictable nature of arbitration in the first place. I'll also say that my learned friend has not, perhaps for the want of time, been able to address this issue of unconscious bias. When one looks another person in the eye, there is a problem. And for an academic, it should be clear. The prevalence today of blind examinations, for example, where the professor does not know the skin color or national origin or class or the way a person speaks, is seen as a fundamental part of fairness in the academic circles. Why not in arbitration? With that, I will conclude.
Thank you, Noah. Patricia.
I'm all for inclusion, and I'm all for trying to avoid unconscious bias. But I don't think you're going to eliminate it by eliminating hearings, Noah. There's still going, excuse me, Mr. Rubens, there will still be witness statements, and the witness statements will indicate the age, the occupation, where the person is, their name. It will indicate a lot of information which could trigger completely unjustified biases. So you're not going to eliminate, they're not going to be secret witnesses who don't have an identity or background, who are not subject to some kind of check. And it's going to make it very difficult for those cases where there may be conflicting interpretations of the important documentary evidence, or conflicting factual issues where there are very little documents and may favor civil law lawyers who have a greater documentary record in which to draw upon. That was pointed out by Paula Hodges in an article already a decade ago on this topic. Importantly, arbitration requires trust. It requires trust in the tribunal and trust in the process. If users want this, then they would put it into their agreements. They can already use it. And I don't think it's fair to compare fast track arbitration expedited with complex cases. And importantly, I think one must bear in mind that it's not just public policy that may be an unruly horse. Arbitrators can be an unruly horse, and the reins on them is party autonomy, party agreement. And if we shift to a presumption to apply in all cases, that will mean that a party who is arguing against not having its hearing, live or remotely, will have to convince the arbitrator that that presumption has been overcome. And where is that presumption going to be embedded? How will it be implemented? Who is going to provide some kind of control over the discretion of the arbitrator to eliminate the hearing? Will it be in the rules? Do you suggest putting it in legislation? How are you going to make it compatible with the right to a hearing, which is embedded already in instruments throughout the world? This is a bad idea that will bring bad problems. If people, clients, parties want to go documents only, there already exists opportunities to do that. So I think it's better to sell it in the particular case where the circumstances justify it and the parties want it, rather than strangulating arbitration with such an onerous presumption. Arbitration is not litigation. It's private, paid for the parties, by the parties, and it is a one event, a one hearing opportunity.
Thank you, Patricia. Thank you very much to both. Now let's see who has convinced our viewers and listeners. You should soon have the poll, the QR code on your screens. And we will do the poll again once it's there. It could also appear apparently in the comments on the YouTube channel. This has been, there it is. So either you use the QR code or the link in the comments. So for or against the presumption of arbitration without hearings. And that will make arbitration great again.
Well, you got the tough argument. I thought you did a terrific job of trying to research.
Yes, absolutely. I thought it was, I mean, we could debate for forever, but it was super interesting.
I'm not sure we're going to have changed any minds on this one. Maybe.
It might be. We're neck and neck right now. We weren't before.
Yeah.
You may have won, but we changed our mind. See, you're winning, Noah.
Oh.
How about that?
Don't influence them, Patricia. Don't influence them.
No. Is it the same total as before?
I think it was the diversity argument that won.
Okay. Is it over? People are shy.
Is the total
to vote.
The same as before?
I think before it was 11 plus 6, wasn't it? I can't remember. I didn't note it down.
I lost in a big way.
Okay.
And now it's, I can't see.
Equal almost. Yeah. Okay.
And the same total? Almost the same total.
Almost.
Cool.
I think that's it, guys. No.
Oh, you got one. You got one at the end there. Someone felt sorry for you.
We were here trying to change minds.
It's super interesting. I mean,
excellent.
I think, so the end result is 8 yes and 8 no's. So it's quite equal. Thank you very much. Annie, we still have 4 minutes. So Noah, Patricia, any follow-up comments?
Yeah. I mean, the interesting thing, of course, is I totally agree, Patricia, that you need to provide people what they want. And the suggestion is not, of course, that you impose this on everybody, but that you would incorporate it in a certain set of rules, which would otherwise be normal rules, not fast-track rules, but they would have a presumption against live hearings, right? A presumption, and then you could say discretion be exercised based on such factors as, complexity, like the need to cross-examine witnesses, all that kind of stuff. And then you have that on the shelf as an option for people to incorporate into their contracts. I mean, it just wouldn't work to say all arbitration is going to be on an assumption that there's no hearing. But it would be interesting. Then you could test the presumption. That you could test the thesis that people want this, right? And the idea is, I think that a lot of hearings happen because counsel are used to it and they convince their clients that it's necessary, and they think they get some advantage from it. Whereas ex ante, a client itself may say, do we really need that? If they're told that it's going to cost, say, 1/3 of the total cost is a hearing, and maybe we don't need any witnesses, and if we do, maybe it'll be uncontested, and I don't know.
Yeah, but one of the potential risks, who knows, might be that if that started to work its way into rules, instead of it being an option embedded into different guides and things, it's an option to consider for some or all issues, not to have a hearing or to consider that. But then if it became a presumption, parties might start putting into their arbitration agreement that they have, that they want to have a hearing in order to get out of the presumption. Sure. And then you may end up with a real problem that is in the arbitration agreement, and then discretion when you get to an actual dispute is actually limited so that the effort to create the presumption could backfire.
Well, I presume that people would rather than putting into their contracts a complete override, they just reset the presumption. They'd repeat, for example, the ICC rules, which say the tribunal, if one of the parties requests a hearing, there will be one. That is what the ICC rules say, right? So, presumably if that's what you want, but you otherwise want these rules, then you'll just put your contract, notwithstanding article so-and-so of our rules, if one party wants a hearing, they will have it. Because for now, there is no discretion in the ICC.
That's kind of the Hong Kong approach. That's kind of the Hong Kong.
In the ICC, there's no discretion.
Yeah. Under ICC, there's discretion with expedited. No, under expedited procedure, the tribunal can decide not to. Although in majority of cases, even in expedited, the tribunals it still do the hearing, even if a party, one party says it doesn't want to. So if the one party says I want a hearing, my experience is that arbitral tribunals do a hearing.
Yeah.
SEC rules are the opposite. They say that the hearing will be an exceptional.
Yeah.
Right.
So it doesn't make a
Fast-track.
presumption, but it says with the expectation, if you've read the rules, your expectation should be that it would be exceptional.
Yeah.
Well, guys, our time is up. I was super happy. It was a privilege and a pleasure to spend half an hour with both of you. Thank you very, very much, Patricia. And thank you, Noah, for this debate. Have a lovely afternoon. And it's now time for the next session moderated by Artem Dudko. Thank you very much to all.
Thank you.
Thank you, Maria.
Thank you. Thank you.
Good time of day, everyone, and welcome to session 4 of this inaugural annual arbitration conference of the Ukrainian Arbitration Association. And this session is going to look at the fascinating question of the use of illegally obtained documents and materials as evidence in arbitration. Great. I can see all of our great speakers. The question that we're going to consider today is not a straightforward one. It definitely has at least 50 shades of grey in terms of possible approaches and answers to it. And today we're going to be guided by 4 excellent expert lawyers who will share their views and insights on this question. And they are, first of all, Markian Malski is a partner and co-head of international arbitration, litigation arbitration practice at Arzinger Law Firm. He is the author of 4 books, more than 100 scientific papers, and more than 300 articles and commentaries. Clearly, he is perfectly qualified for this. The next speaker is Irina Chimchyshin, who's an English solicitor advocate and an established international arbitration specialist. In February 2019, Irina set up Chimchyshin Arbitration, focusing on her career as a full-time international arbitrator. Irina Timshin is a polyglot. She is fluent in English, Ukrainian, Russian, has working knowledge of German, and speaks French and Polish. The next speaker is Kawar Qureshi QC, who specializes in commercial litigation, arbitration, and international law. He has undertaken arbitrations and litigation for and against commercial and state parties from more than 70 states. He is the only advocate ever to have acted both for India and Pakistan in high-profile disputes between the 2 states in the International Court of Justice. And last but by no means least, we have Laurence Ponte, who is counsel at Archipel, a boutique international law firm with offices in Geneva and Paris. And prior to joining Archipel, Laurence practiced international arbitration at La Live in Geneva and worked as counsel at the LCIA, where she administered over 150 arbitration proceedings with particular focus on Ukrainian, Russian, and CIS-related matters. And I am Artem Dudko, a partner at Osborne Clarke in London. Now that everyone is introduced, let's dive into our discussion. And to begin with, I would like to set out the legal position on the issue of illegally obtained materials and its interaction with the practicalities. And I invite Kawar to start our discussion. Kawar, over to you.
Artem, hello. I hope you can hear me.
Yes, I can. Perfectly well.
Firstly, it's a pleasure for me to join you all on this discussion of an increasingly important topic. And I'll start by making some overview comments. We've got a conflict between 2 principles: vindicating the truth and preventing crime, protecting privacy. What I propose to do is to give you an outline of the approach of the English courts and the situation in England, where in England, the situation is capable of being explained very simply. Apart from evidence obtained by torture, and the leading authority on that case is a very recent decision of the Supreme Court called Belhaj versus Straw, evidence is admissible. And there's a secondary question, namely, what happens in terms of evidence that's been obtained where the evidence has been obtained improperly? Well, there may be subsequent consequences, but that doesn't affect the admissibility of the evidence. Evidence may have been obtained by the commission of a crime, might have been obtained by committing burglary, by violating the Data Protection Act, by computer misuse. It may have been obtained by tort, trespass, conversion, breach of contract, breach of confidence, by violation of the right to privacy contained in Article 8 of the European Convention on Human Rights. All of those are factors that the court will take into account in determining the weight of evidence, an English court, and not admissibility. One of the most important cases that confirmed this was a decision of the Court of Appeal in a case called Jones versus the University of Warwick, where clandestine recording of an individual who'd made a personal injury claim, including getting into his house without permission, was admitted to determine whether or not the personal injury claim was proper. But there was a sanction that was applied by the court for this covert action, namely costs. Throughout the proceedings, the costs that had been incurred by the victor were disallowed and the costs on the other side were allowed. Another consequence of the attempt to use evidence that's been obtained illegally so far as courts are concerned, a decision of our court of 1999 of Mr. Justice Ricks in a case called Dubai Aluminium versus Al Alawi sets out very clearly that if we as legal advisors are deploying evidence before our courts that has been obtained through criminal processes, that means access by virtue of burglary, Data Protection Act violation, the court can and will pierce legal professional privilege and order production of these documents. So that's a court, and that's the English court position. Pretty clear, admissible. The issue that then turns on weight, relevance, and what sanctions, if any, the court will apply. That depends on the gravity of the breach. Arbitration. Well, the arbitration institutional rules are pretty silent. You've got a duty to act in good faith on the part of the parties, and you've got fairness, equal treatment, equality of arms. Is there a legal impediment? Well, the IBA rules on the taking of evidence, which have just been revised as of 17th of December 2020, at Article 9.2, require the tribunal not to admit evidence if there is a legal impediment. What does the legal impediment arise from? Possibly the applicable law of the jurisdiction where the arbitration is seated, maybe even the applicable law where the evidence was obtained. Very recently, 17th of December 2020, the modification that's taking place to Article 9, and it's come into effect on the 15th of February of this year, it's an important modification, Article 9.3. Now, an arbitral tribunal may, of its own volition, or if asked by the parties, exclude evidence obtained illegally. The commentary, which you should look at to the IBA rules, explains that the provision is permissive, it's not mandatory, largely because of the differences in approach in different jurisdictions. I mentioned the approach in our courts. In America, because of the US constitutional framework, there's something called the Exclusionary Principle, and that also applies in some civil law jurisdictions thanks to constitutional law. Now, very briefly, I've mentioned 3 cases where the question of illegally obtained evidence has been considered. Firstly, the International Court of Justice, which I've had the honour to appear before, in a case called the Corfu Channel case, the UK against Albania. UK argued that Albania was illegally, improperly preventing free access through its territorial waters. To prove its point, the UK collected mines from Albania's territorial waters. Now, what the ICJ held was, by going into the territorial waters to collect mines, the UK behaved in a manner that violated Albania's sovereignty. However, the evidence wasn't rendered inadmissible. It was deployed and had regard to by the court to determine that Albania had acted unlawfully. 2 other decisions, Methanex versus the USA. This was a NAFTA claim brought by a Canadian party. Its product, which was a fuel additive, had been banned in California. A decision of the NAFTA tribunal in 2005 excluded evidence that had been obtained initially, Methanex said, by trawling through bins, which are in a public space. And then Methanex said, well, actually, maybe the bins were in a private space, but the door was open. And the arbitral tribunal concluded that none of that evidence was admissible, not least because of the inter-trial rules requirement for parties to act in good faith and for the parties to be treated equally. The tribunal also held that the evidence in any event was of marginal significance. Very recently, more recently, there were secret recordings that took place, contrary to Romanian law, in the context of a claim that had been brought by Romania by EDF. And in a procedural order, number 3 of 28th of August 2008, the Arbitral Tribunal excluded the evidence that Romania had obtained, covertly recording one of the claimant's associates, on the basis that this was a violation of procedural fairness and the duty of good faith. So ultimately, now that we've got this new rule change, what does it do? It enables the arbitral tribunals to weigh questions of proportionality much more carefully. We can see a big difference in terms of English court approach, the International Court of Justice approach, and the few arbitral tribunal decisions that we've seen. If the evidence is already in the public domain and it cannot be attributed to the party that's seeking to deploy it, well, it's unlikely to be excluded and there's unlikely to be any sanction. I'll stop there to invite any questions and discussion. Thank you, Artem.
Thanks, Kua. Clearly, there is, as expected, a whole variety of approaches from different courts. And then let's just hear from some of our other speakers on some of their experience that they've seen in the differences in approach. Irina, turning to you for a short comment on the differences in approach by courts to this issue. What would you like to say?
Well, I think that obviously, as just a very good summary was given by Kava, is that the English court takes a clearly open view on that. And in my experience, both as counsel previously as also as an arbitrator, I have to say that usually it is very open question that evidence is admitted. We always can, any evidence goes, and initially I was quite surprised that this may be the case, but reality is the pursuit of the truth seems to be more important. I will address later in relation to enforcement another case which Hava didn't mention, which is Sinaco International and RBRG, which is the most recent Court of Appeal case, which sets up very useful principles in relation to the illegal evidence. But obviously I'll leave it for later.
Thanks, Irina. And Lawrence, what is the approach in Switzerland?
Thank you, Artem. So from a Swiss perspective, what I think is interesting to mention is that before 2011, so about 10 years ago, so before the harmonization at the federal level of both the civil and criminal proceedings rules, the rule established by the Swiss Supreme Court was basically that illegally obtained evidence was never admissible. But the position has significantly changed since then, including in light of the case law over the last 5 years. And it now seems quite clear that the test to decide on the admissibility of unlawful evidence is now unified. It is a balance of interest test, although there are a few nuances depending on the nature of the matter. So, in civil law matters, for example, in practice, the same tests will be applied to determine whether whether evidence is both legal and admissible, namely whether there is an overriding interest in finding the truth versus the personality rights potentially infringed. In criminal law matters, the Swiss Criminal Procedure Code provides that illegally obtained evidence, such as, for example, evidence obtained or based on systematic surveillance conducted by private detectives, is inadmissible unless it is essential to secure a conviction for a serious offense. And I would say that, as a matter of administrative cases, the approach is more or less the same and was actually underlined by the case law by a decision of the European Court of Human Rights rendered in 2016, which I think is a very interesting case. Now, in Switzerland, in the context of arbitrations seated in Switzerland, all those rules are not bound on the arbitrators, but nonetheless, Swiss law may directly or indirectly impact on the decision making by the arbitrators.
Great. Thanks, Laurence, for that. And Marc-Jan, turning to the host jurisdiction for today's conference, Ukraine. What's the situation? What's the situation there?
Thank you, Artem. Thank you, dear colleagues. Great to see you all here with our participants joining us. I will say that this topic is still very much developing in Ukraine. I wouldn't say that this is already, a question well answered. If we look on the case law, if we look on both criminal and civil matters, then I would say in criminal this is much more of a subject which is such a groundbreaking thing, because from criminal cases we see that very often the admissibility and legality of evidence may break the whole case. And that is what we've often seen in a number of cases. In the civil law matters, I would say that judges or arbitrators will probably take into account the evidence, and then, as already mentioned, will be an approach of truth somehow prevailing over the admissibility of a certain part of evidence. But I would say that the arbitrators or the judges in those cases would most certainly substantiate their reasoning with other evidence. So I would draw a line here that in criminal matters, the judges would much more strictly look into the admissibility of certain illegal evidence, and this is often the case where the lawyers try to bring up this matter. And then if the judges find it inadmissible, then basically I would say it could ruin a case of the prosecution, for example. And that is very often the strategy of attorneys in criminal cases. In civil, as I already answered, I would also point that the representatives of a party, of course, if they see an inadmissible evidence, for any lawyer, I think this is a red flag to start acting. And you would, of course, bring this up immediately and say, well, look, this is inadmissible because A, B, C. And then this would, of course, be a very big subject for debate before the decision-making body. But as I'm telling you, this is still a very much terra incognita in many issues. And I believe only based on case law we can see some examples. But there are no general rules yet. And of course, we will be discussing this during the day of today.
Thanks, Marc-Jan. It seems to be that although there are different approaches from different jurisdictions, there is still an element of trying to accommodate evidence, but depending on the severity of how it was obtained is playing an important role. And I think that's the next question that we're going to turn to, is of all the different kind of possibilities of levels of impropriety and how the courts deal with that. So, Laurence, can I turn to you to introduce this next theme to us, after which I'll go to Kawar for some quick comments before he has to, unfortunately, depart our session. So, Laurence, over to you first, please.
Sure. Thank you very much, Artyom. So I think I will start with a practical example, and that's that of an arbitration case seated in Switzerland and governed by Swiss law, in which my firm was involved a few years ago. In that case, the claimant produced and relied on recordings of phone calls or live discussions, including in London clubs, between representatives of both sides, which had been made over several years without the respondent's consent at the time. And the respondent argued in particular that the recordings were illegally obtained in view of the Swiss criminal code. And the claimant in reply first argued that because the recordings were not made in the territory of Switzerland, Swiss law had actually no bearing on the legality of the recordings. And it further argued that in any event, as a matter of Swiss law, arbitral tribunals have broad discretion to accept evidence, whether legal or illegal. And it relied in particular on the Swiss Code of Civil Procedure and also on the case law of the Swiss Federal Court, which found in the context of a sport arbitration case that the arbitral tribunal could admit illegally obtained evidence where the interest in discovering the truth outweighed, I quote, the legal interest harmed by the acquisition of the evidence. As a matter of legality, the respondent replied that it is still an offense under Swiss law to use such recordings, even if it was not an offense to make them in the country they were made. And as a matter of admissibility, the respondent replied that unlike in the sport arbitration case relied upon by the claimant's interest was not worthy of any protection, as it was simply private business interests, and that there was no reason why this private interest should prevail over the right to privacy of the respondent and its employees, whereas the sport arbitration case related to disciplinary proceedings and quasi-criminal behavior by the party seeking to prevent disclosure. So what was the arbitral tribunal's decision? So first, by way of a procedural order, the arbitral tribunal ruled that the recordings should be kept on file, but that these did not prejudge the evidentiary weight which the tribunal would give to the recordings. And the tribunal acknowledged in particular the fact that the recordings were made by the claimant without knowledge, let alone the consent of the other party to the conversation. And it indicated that it would bear this in mind when assessing the evidentiary weight of the recordings. Then, at a second stage in the final award, the tribunal decided that given that both parties had extensively relied on the recordings in the course of the proceedings, it would rely on them only to the extent that they corroborated findings at which the tribunal arrived on the basis of other evidence on the record. And this leads me to make three remarks. First, that the tribunal was not primarily concerned by the fact that the recordings would have been illegally obtained as a matter of Swiss law, but rather that they had been made without the consent of the other side. So the tribunal was concerned by the fact that the recordings had been obtained in a disloyal or unfair manner rather than in an illegal manner. And as we have just heard, national laws and courts treat the making of audio and video recordings and other practices such as the leak of documents to the public domain in different ways. And I'm thinking in particular of two decisions rendered in the context of arbitral proceedings by the Israeli and Italian courts, respectively, involving the Economic Intelligence Agency Black Cube, in which both courts found that the use of false identities and the making of secret recording by the Black Cube agents was not illegal. And there is certainly an increasing number of situations where arbitrators are confronted with the issue of admissibility of evidence that is neither manifestly unlawful nor inadmissible, but that raises some questions of fairness regarding the taking of evidence. And as we've heard as well, since the principle of fairness is precisely a cornerstone of the arbitral procedure, it seems to be the proper angle, or at least one of the angles from which arbitral tribunal should deal with the issue. And this is what was made, for example, by the tribunals in the Metanex case, which was referred to, and in the Libanenko case as well. But at the same time, a party which is weaker than the other, or when it comes to establishing serious facts or offenses such as corruption, the use of tactics in obtaining evidence may appear legitimate or more legitimate. And this is why fairness should probably be envisaged from a global point of view. And the best way, as I see it, to achieve this is perhaps to apply a balance of interest approach. It's probably the best way to grasp the whole spectrum of seriousness of illegality / unfairness in obtaining evidence, and how this should affect the use and admissibility of evidence.
Laurence, if I can just, sorry, if I can just pause you there. I know Hawar has a strict stop time that he needs to do, so I'll just turn to you, Hawar, for any quick comments before you leave us. Anything to add on this point?
Yes, thank you, Laurence. That's very helpful. And my apologies for having to depart. It's a fascinating discussion. Ultimately, the balance, it's reflected. We have a statute called the Police and Criminal Justice Act of 1984, Section 78. It's about probative value versus prejudicial effect. So there are essentially three elements. Firstly, how relevant is the evidence? Is it consistent with other primary evidence, supportive of primary evidence? Second, how was it obtained? The greater the turpitude, i.e. the more serious the violation of criminal law or right of privacy, the more difficult it is for a court and or tribunal to admit it, in the sense of to allow it to have influence on the decision. And then ultimately, the question is, once we've admitted it, if we've determined that it's relevant, what other sanctions can be applied? And we've seen that consistently what happens in the English courts is that once it's admitted, if it's deployed, if it's successfully deployed, then the sanction that the court can apply is censure by way of costs. So, Artem, if I can be forgiven on that point, thank you very much. My apologies again for leaving so abruptly, but best wishes for the remainder of the conference.
Of course, Hawar,
which can be circulated.
Thank you very much. Yes.
Thank you. Take care. Bye-bye.
Take care. Bye-bye. And Laurence, apologies for interrupting you, but please continue. But I think I made some helpful additional comments to that.
Of course, no. Thanks a lot, and I'll try to be short. But just to bounce back on what said, I think that in making this balance of interest exercise, arbitral tribunals, although they are not necessarily bound again by national laws, should not hesitate as a matter of guidance to look at the criteria established by national laws, national courts, and also international courts. And I have already mentioned what are the criteria taken into account by Swiss statutory and case law. And again, if those criteria do not apply directly, they still constitute helpful guidance in my view. I also mentioned a 2016 decision of the European Court of Human Rights rendered against Switzerland, which I find useful in that for the courts, the issues to be examined were first whether the applicant was given an opportunity to challenge the authenticity of the evidence and to oppose its use. Second, the quality of the evidence. Third, the circumstances in which it was obtained and whether these circumstances cast doubts on its reliability or accuracy. And finally, whether the evidence in question was or was not decisive for the outcome of the proceedings. So it more or less overlap with the criteria we've heard. Last one point, I would like to emphasize on the significant role played by the CAS, so the Court of Arbitration for Sports case law, in providing guidance in this respect. And I feel that I ought to do so, since the CAS is based in Switzerland. And I would like, for example, to mention the Fusi Malohi versus FIFA case, in which a tribunal conducted a thorough balance of interest exercise and took into account, for example, the nature of the infringement, the interest in getting at the truth, the evidentiary difficulties for the interested party, the behavior of the victim, etc., before deciding that the interest in keeping recordings confidential was outweighed by the interest of FIFA to use those for disciplinary purposes. And a similar approach was also taken in subsequent CAS decisions concerning match fixing. Now, while the interests of discovering the truth are usually strong in the context of sport disputes, they do not necessarily prevail in all cases, and that is particularly so with respect to coerced evidence. And with this, I'm done with my remarks, and thank you very much for your attention.
Thanks, Laurence. It's really, really fascinating. Markian, turning to you for some brief comments before going to Irina. What I'd like you two to comment on this stage is it clearly seems to be that the approach generally is one about balancing the different interests. However, that approach, although theoretically gets to the right result in terms of fairness, is very unpredictable. And would it be better if there is a much more black and white, clear-cut approach, which is less fact-specific? What do you think, Markian?
Thank you, Artem. The first counter question appeared to me was, now, how does that make you feel? And I think that basically, this is very subjective. And I mean, how does this make an arbitrator feel if he sees a certain part of evidence being illegally obtained? And I think the spectrum is broad of how does this make us feel. So this is, of course, very subjective. And I think what you say by whether we would need something being written and accepted as black and white, I think here is much more complicated. So as the spectrum of seriousness, as we've formulated this in our discussion of illegality or impropriety, is very much different and depends on case-to-case basis. I think this will be very complicated for the lawyers to sit down and firstly formulate and then secondly agree upon this. So I do believe that this will remain an open question for many, many years still. And of course, we lawyers like black and white things. But I think this world is much more colorful, and I believe that in different cases this may be very, very much different. So I don't think we need something very strict. We may have something soft on those matters, but I think this is exactly for the case law to formulate, and then the other arbitrators feeling, in a way, the case will be able to choose from the existing case law how to judge upon this matters. I do believe that some helpful guidance would be, of course, good. So I'm pro discussing such matters, of course, on conferences and so on. So we can say that already some criteria from different case law exists, but I would definitely leave this to a broader discretion of the arbitrators, how in a definite case they would see this situation themselves. Thank you.
Thanks, Markian. I actually think that we as lawyers prefer it when it's much more colorful, as it gives us much more opportunity to practice our craft. If it was all very obvious and black and white, there would be very little for us to do. Irina, as a experienced arbitrator, what do you think on this kind of the range of approaches and this balancing exercise?
Well, in the last year, I sat in two cases, in one as a co-arbitrator and the other as a sole arbitrator, where I had to face the issue of illegally obtained evidence. more particularly forged evidence, which was clearly forged, but that did not make the issue any easier, because when you totally understand what you have facing, and the most important issue is how to make sure that you make the right decision, so the ultimate award in this case will be enforceable and not challenged on the basis that evidence is improperly admitted, not admitted, and so on. So how do you face these issues? And in that context, I have to say that I think I actually do welcome introduction of the revised IBA rules on taking evidence, because that's actually the first I think, codification, if you wish, of the existence of illegally obtained evidence and what the tribunal is meant to do with that. And I think the fact that it actually specifically provides for excluding evidence obtained illegally actually implies that prima facie illegally obtained evidence is admissible unless established otherwise. Okay, we probably have known it for a while, but it actually, for an arbitrator, it makes it much easier morally, and that you are doing the right thing when you actually know that you have to decide if there is any good reason why that evidence shall not be admitted. And of course, it also greatly depends on the seat and depends on the applicable arbitration rules. In that regard, I would say Singapore arbitration rules probably slightly ahead of the curve, because they do exclude interference of the applicable law or application of applicable law to the issue of admission of evidence, in which case it actually cuts the submissions half, especially if you speak about parties from the Eastern Europe who are particularly keen on making submissions in that regard. But with that, I would, if you don't mind, I would like to move to the issue of enforcement.
Yes, of course. Of course. No, well, I think we're ready, and it's clearly it's very important, because when arbitrators have to consider these issues, it's really important that they don't only consider the issues of the currently applicable laws to their procedure, to depending on where they're seated, what is the applicable substantive law, but also to consider what possible jurisdictions the ultimate award will be enforced in, and what would be the approach of those jurisdictions on these issues with a view to potential challenges. And Irina, back to you to kind of set the scene for that next theme for us.
Yes, thank you. Well, first of all, I will start with possibly basics, but I think it's important to mention that obviously topic of enforcement, we all have to remember that the enforcement of arbitral awards is one of the key attractions of international arbitrations. It's a selling point which most clients and parties actually agree to arbitrate on, because they understand that gives them that extra advantage of enforcing the award in 159 jurisdictions, as if I remember rightly. So, and also, obviously, New York Convention, which governs enforcement, is drafted in such a way that the grounds for refusal to enforce an arbitral award are limited to a rather narrow list of irregularities. So, and these irregularities are set out in Article 5 of the New York Convention, and most of them are focused on arbitral procedure, which I don't propose to address in great detail at this point. But the most commonly invoked, and I think most practitioners will agree with me here, is Article 5(2)(b), which provides that the court may refuse enforcement if it would be contrary to the public policy of that country. And I think in the last 5 years, I probably can count on one hand arbitrations where that argument was not brought still in the actual pleadings as a slightly covert threat to the arbitrators. What happens to you if you don't do the right thing? Sort of just kind of taste of things to come. Yes, so how to deal with that? Obviously, the public policy exception is the most vague ground due to its constantly evolving nature and multi-jurisdictional nature, and because it's interpreted differently in different jurisdictions. Hence, it's obviously the first choice for the parties to challenge an award, because you can basically throw a kitchen sink into that and hope it swims. So, and obviously, where it concerns illegally obtained evidence, that's a most likely ground which would show. So now, most arbitral rules provide that, as we heard already here very helpfully from previous speakers, that the power to determine the admissibility, relevance, materiality, and weight of the evidence is on the arbitral tribunal. So obviously that shifts the burden, and as an arbitrator, that's where you have to think carefully how to make sure that you comply with the due process and yet obviously do the right thing, but the decision is well balanced, and you achieve that you perform that balancing exercise to perfection, to the extent that is possible. And again, as I said, I think appearances of things like Article 9.3 is very helpful, 9.3, of course, of the revised IBA rules, because there had to be at some stage some saying that allowed illegally obtained evidence exists. And I think I probably would like to see them further, illegally obtained as opposed to unlawfully obtained or unethically obtained, because obviously what is illegal, strictly speaking, and what is the old good English argument, I was walking on the street and I found an envelope, I opened, wow, it's bank accounts, which are so handy for my freezing injunction. So, it's not illegal really, it's just you found it on the street, and that's the way it is. And we all know that. But the point is, it would be helpful if we had that clarification further, because it would make life easier. But I personally found very helpful even the commentary of the IBA 2020 Review Task Force, where they use an example of a recorded conversation in a country where recording conversations are prohibited as something which could be admissible. And that already gives a certain indication what is acceptable, and certainly it resonates with what Laurence said earlier, that there are certain acts which parties already can predict. But I think it's very important to draw a line and be very careful that parties are not encouraged to perform this act knowing that it probably will be admissible. And we all know from the practice as counsel that you have always a client who will say, oh, what evidence do we need to win this case? Ominously suggesting that just tell me what's required, you will have it tomorrow. So, or whenever. But it's obviously very dangerous grounds, because that can be interpreted as invitation to, illegally obtain evidence or manufacture some if there isn't any. So how do the actually courts, and we today heard some instances, treat challenges of arbitral awards on public policy grounds? I mean, obviously we all had threats in the pleadings in actual arbitration, and thankfully it never reached courts, at least in my case for sure for now. But how the courts treat it, and here I would actually bring two examples. And one of them actually from Switzerland, and I believe Laurence may have mentioned it generally, but I thought I may mention it because it has connection with Ukraine. So I thought it actually would add the local, and you, Laurence, you probably know what I'm talking about. It's a case between the Swiss Federal Supreme Court in 2014, which related to the courts of arbitration for sport decision in a match-fixing case between two Ukrainian football clubs. So, and that was Karpaty Lviv and Metalist Kharkiv. So, and that was quite, I will not go into merits of that case, but bottom line is the party who lost on that particular one, which happened to be Metalist, actually appealed to the court, and the appeal was based on the argument that the procedural public policy was violated by relying on illegally obtained evidence. And that's where, as Laurence already helpfully mentioned, that Swiss Supreme Court held that illegally obtained evidence is not inadmissible. So, which in all cases, and the balancing exercise between the truth, discovering the truth, and the interest of preserving the privacy of the parties have to be conducted. And in that particular case, given the gravity of the offense and the public interest in the fight against match fixing, it was obviously rejected. So that's one case which definitely made resonates with this topic. Second one, which I mentioned at the outset, is Sinaco International and RG UK Trading. So that's a Court of Appeal case, and a case which went a long way. Basically, again, in the interest of time, just in a very brief summary, it's a case of Chinese
Yes, we need
company.
to move on.
Yeah, okay.
So basically, if you could,
very complicated case,
Irina.
but basically the award was appealed all the way to Court of Appeal. And here I would just like to say that Court of Appeal, in that case, provided very useful precedent, which I believe for the arbitrators would be extremely useful guidance. And I'll just summarize these 4 principles in conclusion. So first, when public policy is relied upon to preclude enforcement, it should be given a restrictive interpretation and approach with extreme caution. Second, when the arbitral tribunal has jurisdiction to determine the relevant issue of illegality and has held there is no illegality, the English court should not reopen the facts apart from exceptional circumstances. Third one, where on the facts it is found that there is no illegality under the governing law, but is under English law, public policy will only be engaged when the illegality reflects consideration of international public policy rather than just English policy. And finally, in considering when public policy is engaged, the degree of connection between the award sought to be enforced and the relevant illegality will be important. So, and in absolute final summary, so the court actually went to indicate that any public policy considerations are clearly outweighed by the interest of finality, which is very pro-arbitration approach. Okay. And I think it's very positive outcome for the arbitration practitioners and for arbitration community. And it's a very useful precedent which we shall use. With that, I will conclude.
Irina, with very limited time, but thank you very much. I mean, I'm sure all of us could carry on talking about these issues for a very long time, but we need to move on. Laurence, on this issue of enforcement, do you think arbitrators should be considering these issues when writing their awards in terms of will this be challenged at the enforcement change, or should they be more concerned with getting the award right in the jurisdiction where they're writing it?
Well, I think, yes, they should keep this in mind. But as Irina explained, at least from a Swiss point of view, arbitrators are in principle, well, they enjoy extensive freedom in this respect. They're indeed limited by, equal treatment of the parties, rights of the parties to be heard, and public policy, procedural public policy. But procedural public policy is regarded in a very liberal manner by Swiss courts and by the Swiss Supreme Court in particular. And again, as also explained by Irina, the case law in arbitration, in sport arbitration, helps define exactly what means procedural public policy in this context. And I will just quote that, illegal evidence does not automatically concern Swiss public policy, which is violated only in the presence of an intolerable contradiction with the sentiment of justice, to the effect that the decision appears incompatible with the values recognized in a state governed by the rule of law. So again, it shows that where the balance of interest test is carefully conducted, there is very little chance that the use of illegally obtained evidence in arbitration proceedings and the award rendered at the outcome will violate public policy, at least Swiss public policy.
Yeah, thanks, Laurence. That's a very liberal approach, as you say, on that issue. Markian, I'm going to turn to you for the final theme for our discussion, and that is that when issues of illegally obtained materials or documents come up, it potentially triggers a whole range of issues for the different participants in the arbitration, and these would be either counsel or arbitrators, in the sense that some of these individuals have various regulating authorities. There are various obligations that apply on them. And can I ask you to talk to us about this topic and how these kind of considerations affect what actually happens with the legally obtained materials when they arise?
Sure. Now, that is a very, very interesting question, and it all leads to many issues, as you say. So the first would be, is there a duty of an arbitrator or a counsel to notify, for example, law enforcement bodies about the illegality of all evidence procurement? And now, in this regard, the duty, if we are speaking about the Ukrainian law, is still very much silent. And I would say that we had an interesting situation that when still a Soviet criminal code existed, then there was a general obligation to notify of all known crimes, and basically you would have to report on anything. And now the law has changed, and the criminal law is now much more liberal towards those who know about certain crime, and basically they have no duty to report. This is the general approach, and basically unless they do actively something in order to prevent the investigation or to prevent the leakage of information that some crime has taken place, there's very little chance that they will be criminally liable. So there's a very interesting change in the mindset if we take the Soviet and the more liberal and common approach. But if we speak about the illegality of means to procure evidence that is being presented in an arbitral proceeding seated in Ukraine, then we would analyze 4 issues. The first one being the general statutory requirements, including criminal law statutes, then the rules of arbitral institution, and then ethical rules. And those are the main issues to analyze. As I said, in the Lex Arbitri, in the International Commercial Arbitration Law, there are no provisions establishing an express duty of an arbitrator or counsel to notify in such cases. If we're speaking about the general duty, as I mentioned, there is a change in the criminal codes. The current criminal code nowadays says that there may be a liability for failure to report on another person's crime if, for example, the official in certain cases is liable if this official has not reported a crime committed by subordinates or persons under his control. Such acts are qualified as crimes in the sphere of official activity. And then second, knowingly giving false testimonies. This is rather clear, and this may involve providing testimony with the intent to conceal information about the crime of another person. And then third is the refusal to testify, which covers acts committed to the purpose of not reporting a crime committed by another person. And thus, generally, a person has no statutory duty to report about crimes of others. The person must make such a notification only when he or she has a special duty to do so. So this duty must arise based on the law, official position, procedural status, such as witness, translator, or expert, but not otherwise. And then similar concepts apply to those types of illegality that do not raise to the level of a crime, and Ukrainian legislation does not impose any duties to inform about mere procedural violations. If we speak about duties established by institutional rules, most of the rules, LCAA, SCC, Ukrainian rules, contain no express provisions on the duty of a counsel arbitrator to notify law enforcement in such case. The most popular institutional rules in Ukraine also do not impose such duties. And the LCAA rules do provide the possibility of arbitral sanctions against counsel for ethical violations, not only in the form of cautions and reprimands, but also in the form of a reference to the legal representative's regulatory and or professional body. But it would have to be a gregarious conduct indeed that would induce arbitrators to be sufficiently concerned or sufficiently officious to invoke the law enforcement mechanism. And the desire to maintain the privacy and confidentiality of the arbitration process will, I think, further militate against disclosure of anything like this. If we are speaking about the ethical rules, those are still very much soft in Ukraine, and they also do not put such a burden, and it's very much a discretion of the arbitrator or the council in terms of how to react in such a situation. Of course, there's always a right. There's always a right to report. However, I think this is not often the case. If we even though there's no duty, no express duty, I think it is up to everyone to think how to act. And I will just end my brief presentation here with a very interesting case when two counsel have understood during the hearing that both clients to them have forged documents in the proceedings. And it was very interesting to observe when both counsel understood that they are both acting on forged documents in the process. And when the judge understood this as well, he asked, well, is any of the counsel going to claim an expertise regarding those documents? None of the counsel did. And then the judge did not find enough, I don't know, either will of power or legislative grounds to order an expertise himself. And he was basically deciding the case upon what he thought was legal. So this was a very interesting situation. And upon this, I will end my short presentation, and thank you for your audience.
Thanks, Markian. We're all smiling, but it's scary that these things do in fact happen in reality. For some very brief comments, both to Lawrence and Irina, on the situation in your jurisdiction on these additional obligations and regulations. Lawrence, first to you. What's the situation in Switzerland?
Well, in Switzerland, a lawyer who is aware that the evidence has been illegally obtained faces two risks. First, a criminal complaint being filed against him or her, and second, a disciplinary sanction under the law on the legal profession. And that would, in particular, be on the basis of the specific duty of diligence provided for by the law, which imposes on lawyers to defend their clients' interests by using the legal means available. And a lawyer would only be able to defend him or herself by demonstrating that the specific conditions provided for by the Swiss civil or criminal procedure codes are fulfilled. And if Swiss courts may show more flexibility in the case of private individuals, lawyers will certainly not benefit from any flexibility given their legal knowledge. Now the question arises as to whether the sanction would be the same for evidence obtained in a disloyal manner. And my guess is that the risk to face criminal or disciplinary sanction would be the same, would be similar. First, because according to Swiss case law, if the person against whom the evidence is relied upon was trapped, if it did not provide the evidence on its own initiative, the evidence should be considered as inadmissible. And second, because the specific duty of diligence is certainly broad enough to embrace this situation. And maybe just one additional word regarding economic intelligence agencies. I think that they can likewise, face a risk of criminal complaint, but because they're not regulated in jurisdiction as in Switzerland as in many other jurisdictions, I guess, they cannot in principle be subject to disciplinary proceedings and sanctions.
Thanks, Lawrence. And Irina, last final comment from you on...
Okay. As you obviously well know, in England there are plenty of legislation which relates to data protection, money laundering, and you name it. However, before going into any of that, I would say one thing. With the illegally obtained evidence, one important thing is that it's usually an allegations which never, almost never, accompanied by any real action on the ground or any even police complaint or any pursuit of sanctions. Otherwise, it's just merely allegation which is cast mostly to create literally just a bias for arbitrator or purely affect reputation rather than actually get anything tangible. So it would be imprudent and inappropriate for an arbitrator to do any act on mere allegations that somebody forged the document, especially if there is no evidence. An arbitrator shall not play a role of a police man or woman in order to investigate that. It's definitely outside arbitrator's domain to investigate any criminal allegations, because there are certain authorities for that in every jurisdiction, and the party shall not be using this approach in order to actually often derail arbitration.
Thanks, Irina. We, as mentioned previously, we could discuss this fascinating topic for hours, and there is plenty to discuss. Hopefully, the comments made in the last hour have made all of our participants realize some new things, some interesting thoughts, and perhaps, I don't know, Markian, as you mentioned it, there is some scope for some soft law on this particular issue to be considered by some of the arbitral institutions or organizations. But we have run out of time. And so I would like to thank all of the speakers for their very insightful and interesting comments, the Ukrainian Arbitration Association for organizing today's event, sponsors for making it possible, and most of all to the participants for listening. Thank you very much, and see you at the next UAA arbitration conference. Thank you. Goodbye.
Thank you.
Dear participants, with this we conclude our first UAA annual arbitration conference. I will be very brief. I would like to thank all the speakers and moderators, our organizing committee, our technical support team, all our sponsors, all our media partners. Without you, this event would not have happened. And of course, we are immensely grateful to all our participants. Thank you very much for being with us these 2 days, and hope you have enjoyed the program. In case you have any feedback or ideas regarding future UAA conferences, please email to us. The video of the conference will be available at the UAA YouTube channel, so in case you have missed some parts of the streaming, no problem with that. Thank you again. Hope to see you all at other UAA events. And now UAA members are invited to join the general meeting of the UAA members using the Zoom link sent to them by email. Thank you.